May I please, Lordship? My lord, in a very cryptic manner, my injunction petition has been rejected. Now I have been facing threat of my lord commercial activity. Lord, seeking injunction, my lord, I have filed a petition. Lordship, may kindly take up tomorrow, my lord. Some urgency is there, my lord.
Tomorrow.
It's a small
Okay.
matter, my lord. May I please, your lordship? That matter and execution proceeding was staying, my lord. That's a long pending matter. Let it come, my lord, for order next week at any other.
Take a date from him.
Please, sir.
Of
Please, your lordship.
Yes.
This is the old pending matter, lordship. Stay is operating. I'm from the respondent. 19 matter, lordship.
What matter?
RSA, lordship.
RX.
This matter will come for hearing next week, lordship. For hearing? For hearing.
On
Eight.
24th February.
Take your lordship.
May it please, your lordship. Beg to mention item number 17, your lordship. This matter, senior counsel Mr. Bidappa is appearing. He's unwell today. So can it be on 18th of February, your lordship?
On the appeal being made by Mr.
J. Das.
Learned Counsel. So the petitioner raises the matter.
18th of
15th is the motion.
19th. 19th. Deeply obliged.
Madam, the second appeal matter, 2022 matter, services update matter. And if I'm on a hearing matter and day after tomorrow.
Hearing, it should be on in usual course. Raise they will fix the date.
My lord, this matter pertains to my shop, my lord. It's a concurrent.
Maybe.
This is my family matter.
Some
That is
more other
advanced stage,
matters
yeah.
are also pending.
Next week or.
Next week, not possible.
March. The
Yes.
last week of February.
May I please,
March.
Lordship, I have filed a civil transfer petition yesterday, my lord. There is a matrimonial dispute between the parties, my lord, and the next date is fixed in the lower court is 13, my lord. Can it be taken for motion on tomorrow, my lord? This is a simple case, my lord, just wife seeking transfer, while the other cases are also pending, my lord. On
Friday.
on the lower court, my lord, the case is fixed on Friday, my lord.
Maybe,
Lordship, on day after tomorrow. my lord.
maybe lower court will not send you to the jail.
Well, last chance is given for filing WS, my lord. This is the another issue, my lord.
Friday. Yes.
Thursday, my lord.
May I please, your lordship? Lordship, I beg to mention for listing of the RA in the orders following
When?
on 16. Yes. Apply the.
May I please, your lordship, for listing by RSA lordship for orders on Friday lordship,
Friday may not be possible.
On Tuesday, 17.
70. Obliged lordship.
Yes.
May I be pleased, your lordship? In IA Civil 3188/2025 in MSc Appeal 448, we are seeking for listing of orders.
When?
Huh? Last
When?
it was in hearing on 25/9/2025
On 18.
on Friday.
18.
Oh, sorry, Friday 13. Your Honor, again one more. In MSc Appeal 172/2021, we have not received 50% amount. We are the claimant. Matter may be fixed as per conveyance of your lordship.
On 28.
28.
May I please,
Yes, lordship.
lordship, I beg to mention for listing one MFA in hearing. Lordship, it's a old pending matter in the year of 2015. Lordship, matter may be listed next week of.
May it please, Lordship. Lordship, may I pray for listing of an interlocutory application in
Or
for orders, Lordship. Orders.
when?
On Monday?
Next Monday?
Monday.
Okay.
I would like to withdraw one CRP lordship on 12th lordship.
When?
12th lordship. Already infectious matter.
Well,
Yes, withdrawal.
yes.
So, lordship, I beg to mention an I for listing for hearing, lordship.
When?
13, lordship.
13. Good.
Public.
Fixed as first item. Letter number 10.
Norma Kumari is appearing as CBI counsel. She has requested me to apprise the honorable court. She is in the leg on this court. as item number one. Kindly take after 10 to 15 minutes. my lord.
I have bigger option also. I have a small player option. Can it be taken? It's come under the option. So Edinburgh is out of station, also I have given the letter of absence. There's some difficulty to get option. And I think time is also so important. He's busy. Any day next week. Lord.
You see, this is a matter of the year 2014.
Gotcha.
Already 10 years elapsed.
Gotcha. Gotcha. I will-
Okay, fine.
Number three.
Last week. Mr.
Eight problem.
A.
Eight problem.
V.A. Chaudhary, Learned Counsel appearing on behalf of Mr. A.M. Bora, Learned conducting counsel for the respondent. Submits that conducting counsel Mr. Bora is out of station.
Gotcha.
And on such count, he prays for listing the matter on some other day. Pair allowed, races shall list the matter on
24th.
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 My lord, I am for item, I am for response number three, my lord.
Respondent number 3, Mr.
D. Bora.
D. Bora for the respondent number 3 present.
I will put it spotted number two on behalf of Mr. Vigan.
Sir, D. Talukdar. Miss, your name, please?
Miss P. Soikya.
P. Soikya, Learned Counsel, appearing on behalf of Mr. D. Talukdar. Learned conducting counsel for the respondent number
24.
22.
DP. Item for motion, item number 18.
May please your lordship. Lordship, this revision has been preferred against an order dated 5/1/2026 passed by the Learned Civil Judge Senior Division Shankardev Nagar at Hojai in title suit number 56/2024. Before I take my lord to the impugn order, may I submit then, my lord, the sole respondent, my lord, filed a suit, my lord. That is title suit number 56/2024 for declaration of right title interest for cancellation of sale deed, for partition, for recovery of possession, and for permanent injunction, my lord. In the, my lord, the petitioner before my lord are arrayed as defendant number 6 and 8, my lord. If my lord comes to annexure 1, page 14, my lord, the plaintiff, my lord. Page 14, annexure 1, my lord. Page 14, not annexure 1. And
Yes.
this is the first, because Melody will kindly come to page 15, Melody. Page 15, thereafter. Melody will kindly see defendant number 6, 7, and 8. 6 and 8 are the petitioners before this honorable court by way of this revision application. And Melody will see that 6 is the son-in-law of the 7 and father of 8. So they jointly filed a written statement come counterclaim, my lord. They, the petitioner before my lord are 6 and 8, along with defendant number 7, they jointly filed a written statement come counterclaim before the learned trial court. While filing, my lord, the defendant number 7, who is not before this honorable court, defendant number 7 was authorized to file the written statement come counterclaim. In the affidavit, it has been stated that they have been authorized. However, learned trial court rejected our prayer of this authorization, saying that there is no authority, there is no power of attorney to that effect. So that is why we are before this honorable court. And my lord will find at the impugn order at page 50, my lord. Page 50, the impugn order, my lord, annexure 5. My lord, may I read, my lord? 5/1/2026, here put up before me today. Plaintiff side is represented by the learned engaged counsel. Defendant number 6, 7, and 8 are represented by learned engaged counsel. Heard learned engaged counsel for the defendant number 6, 7, and 8. Though it was submitted that defendant number 7 has filed a written statement on being authorized by defendant number 6 and 8, who are his near relatives. However, till date, no any authority public power of attorney has been filed. It is does not satisfy the defendant number 6 and 8 have authorized defendant number 7 to represent them in this suit or to file any written statement. As such, written statement filed by the defendant number 7 shall be treated as a written statement of the defendant number 7 only and not for any other defendant. However, my lord, if my lord comes to the written statement come counterclaim, that my lord will find the affidavit, my lord will kindly come to page 41, my lord. Page 41, my lord. This is the affidavit. And my lord will kindly see at clause 1, my lord, that I am the defendant 7 public counterclaimant to an instant suit counter. I am well conversant and acquainted with the facts of the case. I have been authorized by the other defendant number 6 and 8 claimant to take steps on their behalf in the suit and counterclaim. So there is a specific statement to defect. Only question was that, my lord, we have not produced any authority or power of attorney. But that can be done at a later stage also, my lord. In its suit, my lord, the stage will come for documents and issues also. At that stage also, we can obviously, my lord, bring on that document if required at all. And order 6 rule 15, my lord, if read with order 6 rule 14, my lord, any person can my lord, do it, my lord, if the authorization is there. There has to be statement to the effect that I have been authorized by the other defendant, and all these 3 defendants are, my lord, related family members. 6 is the, my lord, 7 has filed it. 6 is the, my lord, father-in-law, and 8 is the, my lord, wife. However, my lord, all these were not considered, and this honorable court will appreciate, my lord, the learned trial court has never fixed this case for after the filing of written statement counterclaim, has never fixed this case for production of that authority letter or for power of attorney. However, then an observation to the effect in the impugn order that till then no authority or power of attorney has been filed.
So Sena, you
Yes.
come to page number 15.
My lord,
Page number 15.
15.
Yes.
Yes, my lord.
This respondent, oh sorry, defendant number 8,
Yes, my lord.
Sangita Bora Muduri.
Yes.
She is the daughter of
Daughter of
defendant number 6.
6 and wife of 7. So
So whether this affidavit is sufficient to hold that the respondent number 6, no, 7 is authorized by the respondent number 6 and 7 to file the counterclaim on their behalf also.
my lord, in practice, my lord, I'm not saying that whether Leonard, with all respect to Leonard Tragro, what in practice, my lord, we have been doing this, so we have never been objected to it by any of the courts that we have been practicing, my lord. I have a small practice of practicing live even then also, my lord, but we have never been objected. But even if that be so, my lord, the stage for his civil suit, documents and issues will come, my lord. After, because at this stage we are in the stage of written statement, filing of written statement. At that stage also we can file, my lord, at the documents and issue stage. But closing my defense just because of this is a curable defect also, my lord. It can be cured at any stage.
No, where your defense is closed,
The impugn order, my lord,
where it is stated.
my lord, may kindly come to the impugn order. Page 50, my lord. And my lord will kindly see 51. As such, written statement filed by the defendant number 7 shall be treated as defendant number as written statement of defendant number 7 only and not for any other defendants. So,
Maybe, but you may file the written statement now also.
but my lord, for that, my lord, the period is over, my lord. 90
You
days
file an
period.
application.
Because my lord, my lord will kindly see the case is fixed on.
You file an application for extension of the period
But my lord will
with the
kindly see.
written statement.
my lord, for if I file, my lord, then there will be another, my lord, difficulty, because 90 days period is already over. I have already availed this 90 days period.
So that's all right. The 90 days period is not absolute. It can be extended also.
For that, my lord, I will be again at the hands of, my lord, Learned Trial Court.
Definitely,
well,
you
that-
are
that-
already in the hands of the trial court.
Yes, my lord, whether the discretion needs to be exercised by the trial court or not at this stage, because
You show the sufficient reason, definitely the trial court will consider the same.
my lord, if there is an observation by this honorable court, my lord, then, my lord, I may file, my lord. Otherwise, it will be difficult, my lord.
Heard, Mr. NBP Sinha, learned counsel for the petitioner. Aggrieved by the order dated 5/1/2026 passed by the learned trial court. No, learned civil judge senior division Hosai. This petition under Article 227 of the Constitution of India is referred by the petitioner. Referred by the petitioner for setting aside and causing the impugned order dated 5/1/2026 passed in titles of number 56 of 2024. Mr. Sinha, learned counsel for the petitioner, submits that the respondent herein has instituted one title suit being title suit number 56 of 2024, which is pending before the Court of Learned Civil Judge Senior Division at Sankardev Nagar, Hosai. In the said title suit, the petitioners herein along with the defendant number 7 of the title suit file joint written statement cum counterclaim on 13/6/2025, but the learned trial court has treated the said written statement cum counterclaim filed by the defendant number 7 only, not for the defendant number 6 and 8 who are the petitioners in the present petition. Referring to the affidavit enclosed with the affidavit of the written statement counterclaim, which is enclosed with this present petition at page number 22. Annexer 2.
Yes.
Annexer 2, Mr. Sinha submits that in the affidavit in clause number 1, it is categorically stated that the defendant number 7 was authorized by defendant number 6 and 7 also. And in spite of such affidavit being filed, the trial court has accepted the written statement filed by only defendant number 7. Defendant number 7. On the ground that the defendant number 7 has not produced any authority letter stroke power of attorney, and he failed to satisfy that the defendant number 6 and 7 have authorized him to represent them in the suit or to file any written statement. However, without going into merit of the aforementioned order, this court deemed it fit and proper to dispose of this petition by directing the petitioner's hearing to file written statement cum counterclaim separately before the learned trial court with a petition of extending the period if the same is already over. And on such petition being filed by the petitioner's hearing, the learned trial court shall consider and dispose of the same in accordance with law. In terms of this civil revision petition stands disposed of, and this motion says itself. You go and
Obliged.
file an application there.
Yes, sir. Obliged.
Item for reference to special mediation right. Item number 1.
May I please, your lordship? My lord, the appeal, my lord, for enhancement of awarded compensation. My lord. My lord, the petitioner submitted, my lord.
No, you say this letter is listed today under the column or referral to the special mediation drive,
Yes, my lord.
mediation for the nation. Now tell me whether the matter can be referred to the mediation or not.
Lord, I do not have any objection.
You do not have any
I am
objection.
yes.
But whether appearance
The other
completed,
side, my lord,
other
article-
parties entered appearance.
His name has been shown in the cause list, my lord. R.C. Paul.
R.C. Bora. Paul. What are you?
One. One. That's my S right there. S right.
Who?
S right. MS.
Your name is there.
It's also there, but I'm not at this council. But when I was there.
Okay.
There. That's right there.
What is your? Oh, wait for some time.
My
He will contact the council.
So,
Next.
Item 2.
But in this case, my lord, the cannot be settled because award is imposed against the owner of the.
Lordship, we want to go for mediation, Lordship.
Cannot settle
And
because
according to
that-
office note, Lordship, according to office note, notice has been served to the owner. So,
Go and try there.
I cannot settle because the award is not against me. That's 1/6 unit issue company. This is the owner, burden is owner. Defendant, but the owner is not, nobody is considered the owner.
you have served notice, Lordship.
No, it may be, but if the party, if the owner is not available before this court, if we refer the mediation, then who will appear for him?
I will appear for that one of it.
Or Ms. Nanda, learned counsel for the appellant, Mr. R.C. Paul for respondent number,
6, my lord.
respondent number 6.
Come.
Though this matter is listed today for under the column for referral to the special mediation drive, that's mediation for the nation. Yet it appears that the owner of the vehicle, who is arrayed as respondent number,
My lord, no, 3, 4.
or is the president of the president and secretary.
Because it may be matter some, two is the owner, director
The
of
owner.
agriculture, tax engineer.
Respondent number 2.
Two, so government.
Yet the said respondent had not entered appearance, though notice was served upon him as per office note dated 6/2/2026. The office note dated 6/2/2026 also indicates that notice issued to the respondent number 3 and 4 received back with postal remark insufficient address and no such person, hence returned to sender. In view of the said office note, it is provided that the appellant shall take fresh slip upon respondent number 3 and 4. 3 and 4. Registrar shall list the matter after 4 weeks. Will take fresh
Date
slip.
may be given then. Any date may be given.
Correct.
I may be minor start for
No.
On 9 March.
9 months.
Obliged, person. But
Much obliged.
Item number 3.
On the last occasion, my lord, it was my lord, not my lord settled. My lord, it was placed before the my lord, for mediation lordship.
Earlier,
Yes, lordship. Now, on the last date, lordship, the respondent was directed to submit instruction as to whether the respondent is, my lord, willing to my lord, mediate lordship. I am ready, lordship. If it is not possible, then it may be fixed for hearing. I am ready, lordship.
hearing. Okay, heard Mr. M.A. Samuel, learned counsel for the appellant. Mr. K.K. Bhatt, learned counsel for the respondent. Number 1. Though this matter is listed under the column so and so, Mr. Bhatt submits that no purpose will be served by referring the matter to the mediation. Then as such, he submits that the matter may be listed for hearing. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that registrar lists the matter for hearing.
The date may be
When?
fixed, lordship.
25 matter. In usual courts,
My lord, date may be fixed, my lord, very long pending, very long matter, my lord, the old matter lordship.
oh, this is 25 matter.
So, my lord, actually, my lord, the award was, my lord, in 2019 lord, 17 lordship.
17.
That was challenged, my lord, review application was filed, my lord, that was dismissed, that is why lordship.
Okay.
On
Sorry.
19 March.
Obliged, lordship.
Items for admission. Item number 4, order second.
Please, lordship.
Lordship, I think it's possible. I did my senior election for number 1.
Who is your senior? Dinner.
Dinner.
Okay. What?
My lord.
I don't.
Item 5, order measure.
Please go much. On the other, the lordship was pleased to direct them to obtain instruction as regard why I was not allowed to join.
I'd like to place instruction of 3 to place this ladies and gentlemen. Lordship, in the second page, my lord, it has been reflected, my lord, that Sonesh, my lord, she was terminated in the year 2009, my lord. Thereafter, they have received salary, regular salary till that termination order, my lord. Thereafter, on 2015, my lord, the termination order were withdrawn, my lord, and they were regularized and reinstated. Point number 7, my lord. Reinstated as assistant teacher in Mashalpur Junior Basic School, my lord, and and they have and they were allowed to join from 1/4/2022, my lord. An appointment letter was issued in the name of Soneshwari Ramshari as tutor, my lord, and the post was purely personal in nature. Accordingly, she joined as tutor on 2/4/22, my lord, and thereafter they have been receiving their salaries, my lord. and she will be retiring further on 30 June 2026, my lord. So after reinstatement, she was asked to join my lord on 1/4/22, and accordingly she joined 2/4/22.
Hmm.
This is what the record says.
Now, Lordship, may I take your Lordship to page 22, Annexure 1?
Hmm?
Page 22, Annexure 1. This is the initial appointment as tribunal teacher. Second paragraph, Lordship, of page 22. The appointment will be considered for regular scale of pay on successful completion of prescribed training as per existing norms and procedures of education department and subject to satisfactory police verification report. In case of failure to pass the training examination within the stipulated time of 3 chances, his services shall be terminated, for which no claim appeal will be entertained. Now, Lordship, at page 24, this is the certificate issued by the Basic Training Center, by the principal of the Basic Training Center on 9/4/2003, certifying that I have passed the basic training, Lordship. Now, if I may take your Lordship,
You are referring to page number?
24. This is the
24.
basic training certificate issued by the principal, or dated 9/4/2003.
Hmm.
Initial appointment says that if I successfully pass the basic training, then regularization will be considered. Therefore, I have passed the basic training, Lordship. Then my services were regularized. Now, at page 25, this is the service book, Lordship. Now, if I may take your Lordship to
Hmm.
page 28 and 29 of the service book. Page 28, regular scale of pay was given to me, Lordship. At page 29 of the service book, he has passed the Assam Junior Basic Training exam from Cockroach BTC on 12/3/2003 as per notification. She is allowed to draw the usual scale of pay with effect on 12/3/2003, as she is past the BTC wide order dated so and so and so. Now, Lordship may kindly come to page 30 onward. These are the GPF statements, Lordship. GPF account was opened by number account number, Lordship, down below. PED 277609 dated 0107 or dated 4/12/1999. Up to page, Lordship, 35. These are the GPF statement. Some of the GPF statement which I have the next. And page 36, Annexure 4 is the termination order. Page 36, order dated 23 June 2009. This is a termination order. Without giving any reasonable opportunity of hearing, no notice was issued, or straight away I have been terminated, which is a violation of the principle of natural justice, Lordship. In exercise of power conferred upon the Director of Education, Vice Secretary's BTC number so and so dated 13/9/2005, and in pursuance to the order Secretary BTC order dated 6th November 2008, the
No,
services of
Mr. Dhar,
Lordship.
you see, you have been terminated from service by order dated 23rd of June 2009.
Yes, Lordship.
And thereafter, you have been, no, that termination order was withdrawn on 22nd of September 2015.
2015. Yes,
15.
yes.
So the question is whether for that period you have rendered service or not.
Since I have been terminated, Lordship, so I was not allowed to continue my service, Lordship. I was not allowed.
Okay.
Thereafter, on 22nd September 2015, it was revoked. Meaning thereby,
That termination order was withdrawn with effect from 22nd
Yes.
of September 2015.
15.
Thereafter, you have joined.
Yes, I continued. And again, Lordship, by order dated 1/4/22, I was appointed as tutor. Surprisingly, Lordship.
No, the question is after joining on 22nd of September 2015,
Lordship.
whether you have been granted any salary or not.
Salary was not granted, Lordship.
Pardon?
Salary was not granted. For that, one case is pending for payment of salary, Lordship. But I continue to discharge my duties, Lordship. Thereafter, surprisingly, on 1st of April 2022, I was appointed as tutor. On what basis, Lordship? My service was regularized, my service book was opened, GPF account was opened. On 2009, I was without any information, without any notice, I was terminated. And again on 2015, I was reinstated. I was allowed to join and discharge my duties. Thereafter, I was appointed as tutor on 1st of April 2022, and Annexure 7, page 31. Again, I was appointed as on regular basis, Lordship, on 14 July 2022. But I was not allowed to join. I joined, but I was not allowed.
Yes, madam, you say the termination order was withdrawn.
Lordship,
By order dated 22nd of September 2015,
Lordship,
Annexure 5.
Lordship.
Once this termination order has been withdrawn, then our original appointment letter comes to force. This appointment letter dated 4/12/1993
No.
that has not been cancelled by the authority.
It was not been cancelled.
Then how can she be appointed as tutor again? On what basis?
Mockery.
Some anomaly has been there, my lord, because.
Some anomaly has been there.
Instruction, my lord.
Pardon?
It is, this, regarding this, my lord, it has not been clear from the instruction, madam. They have simply said that, after termination order was withdrawn, my lord, she was asked to join from 1/4/22, my lord. And,
What happened to her original appointment letter then?
lordship, that was, the original appointment letter was, said to be illegal, my lord.
How? On what basis? If it is illegal, you ought to have cancelled the same.
That is why, my lord, termination orders were issued, my lord, in the year
And
2009.
subsequent withdrawal of that termination order, then this original order come into force.
Lordship, thereafter they have been accommodated, my lord, in various schools, my lord, as assistant teacher upon verification of their documents, my lord.
It cannot be illegal, Lordship. It may be, at best, it may be irregular appointment. But long period of service from
Heard,
1990.
Mr. Ardhar, learned counsel for the petitioner. Ms. Bora for the respondent in BTC. Any other respondents?
Lordship,
You are for? Elementary education. Argument concluded? No, person to order dated 9/1/2026 and 2/2/2026, Ms. Bora has obtained written instruction from the authorities and produced the same before this court. Argument concluded, judgment reserved.
I'm praying for retrospective effect, Lordship, from
We'll say.
Lordship. Deeply obliged.
Next.
Number 6.
Take this lordship. Petition under section 24 of the EPC law for transfer of the divorce petition filed by the respondent husband from Tezpur, from Difu in Karbi Anglong to Tezpur in Sonitpur.
From Difu to
Tezpur, Manoj.
Tezpur.
Yes, where the petitioner is presently residing and her matrimonial, her parental home is there, Manoj, at Tezpur. Manoj, the petitioner was married, Manoj, to the respondent on 31/1/2024, and thereafter they settled their matrimonial life at Auranghat in Karbi Anglong, Assam. And however, within 6 months, Manoj, of the marriage, she was forced to leave her matrimonial home. And in spite of whatever efforts were made, by party, there has been no.
Okay, Mr. Secretary, what is your stand?
Here the wife left the home voluntarily without saying anything else, and we repeatedly asked her to come back. Lordship, I have filed an affidavit, my lord. Para 9, it's clear, my lord.
No, Mr. Secretary, you see, here we are not considering the merit of the original petition. Title cert.
No, since Lordship is right. My lord, since here, my lord, the person is residing at Karbi Anglong, my lord. And the lady is residing at Rangapada. And one case has been filed by the lady at Tezpur. No,
Yes.
And another case is pending in Karbi Anglong, my lord. Now, my lord, since I have to visit the Tezpur, my lord, on that particular case, why not she will not visit to the Karbi Anglong, my lord? My lord, vice versa. Both are in the same way, my lord, where the lady has voluntarily left the home because the fact that she has to look after the old aged parents of the husband. The grounds lordship will see. And if that being the position, my lord, our society will be.
No. I have already told you that we are not on the merit of that petition.
My lord, that is why.
Here the convenience and inconvenience of the parties.
Lordship, let there be 50-50, my lord. Since the boy is appearing in Tezpur, and let her be appearing in the Karbi Anglong itself, so that one time it will be compromised because of considering all these problems and all these things. They will understand. This is my step.
No, you see, the lady, if the lady is residing at Rangapara.
After a month, she has left the house, saying that if you do not get separate, then I will leave you. This is a trend. So let there be 50-50, my lord. Let the one case be remain at Karbi Anglong, let one case be in Tezpur. They will understand the fact and the life of the journey, and probably there will be a chance to unite it. And we feel it for you.
You go and live together, we have no problem. But the question is whether a lady,
Pity, my
whether
lord.
whether a lady can travel from Rangapara to
default.
default.
Well, I have, just now I have seen in the live blog, there are so many decisions, even 225 kilometer when they fail to establish their genuine cause. 225 kilometer is also not a, it's not a problem, but since the communication is there. It was judgment I have
So
seen.
you say, oh,
Telangana High Court,
eh,
Punjab High Court, and Calcutta High Court. Just now I have seen it.
no, maybe. But you tell me, is there any direct connection from Rangapara to Diffu?
Yes,
Bus connection?
yes,
Yes. From Rangapara to Diffu.
yes.
Is it?
And how many hours, my lord, that also my learned friend can apply. What is the length of the journey? My lord, both the parties have expressed that they are ready to have a, my lord, second trial. Both in my learned senior friends, my lord, the reply, and in my petition, both of the parties have said that there is a possibility of reconciliation since the matrimonial life was only for 6 months. But this submission that, my lord, I should be dragged to Diffu to force the reconciliation, that cannot be a submission in law. Because I have said, I am living with my aged parents. You are not a government servant or anything. Already, my lord, they are appearing in the matter under the DV Act. The respondent and his family members, they are represented through a council. Well, what prevents them from engaging another council or the same council to appear in the, my lord, civil proceeding? This is not a family court issue, my lord. They can very well be represented on whatever dates. Now, my lord, the issue of my going, because I do not have any brothers, or I have 3 sisters and my elder sisters are married. They are staying at Shillong and Lamding. I have said so in my petition. I have no other male member in the family except my aged father, who does a my lord, business in a hut. My lord. Whereas in the complaint petition, my lord, I have described how their business, my lord, they are affluent people. And that was the, my lord's bar, that they are affluent, we are not. Anyway, my lord, I'm not going on the merits. Now, the comparative inconvenience lordships will weigh, my lords, and see that which party, because they're already appearing. I have not appeared in Diffu. They are already represented through the council in the CR case, my lord. That they are also admitting. And that is also borne out by the record. So let them appear, my lord, in the case, let the matter be transferred. And whatever mediation, reconciliation, that can happen in Tezpur also. It's not that it has to happen in Diffu only.
And nowadays, when the lordship goes, the ladies are very bravery persons. And
No, what wrong with that?
Earlier occasions, my
No,
lord,
maybe, Mr. Satri,
20
what
years,
wrong
15
with
years
that?
Was a problem. Nowadays, the convenient, this communication convenience is there, and also the
No,
ladies
Mr.
are
Mr. Satri, you say there may not be direct bus connection or train connection from Rangapara to Karbi Anglong.
bus connections are there nowadays available. My lord.
Is it?
Yes.
I'm not aware. Since he has made the submission,
From
he should supplement it.
From Tezpur, there may be direct bus connection with Diffu.
Yes,
I
I'll
don't
have to
think
come, my lord, from
From
Rangapara
Rangapara,
to
there is
Tezpur then
bus
again.
connection.
I have to get the instruction, proper instruction, so that I can have.
Okay, after some time, you obtain instruction.
Item 7.
Before my learned senior friend starts, my lord, trial for record may be necessary because the annexes to our objection has not been annexed.
All right.
And also the objection to the order 1826 has not been annexed. They have annexed their application, but my objection has not been annexed.
No, whether the copy is available with you.
Copy is available with me, but I have only one copy which we as of now.
Okay, you furnish the copy, we'll list the matter on Friday then.
Sorry?
Yeah, some problem. I have to go out next week.
Next week. Okay.
All right.
As agreed by learned counsel for both the parties, receives and list the matter on 18th.
Item 19.
Please, your lordship. My senior is on legs. Kindly matter may pass over for time being.
Who is your senior?
UK does.
Okay, that's okay. After some time.
Orders, item number 8, order date.
Lordship may I please, Lordship? Lordship, this matter is pending since 2013. The 2000 litigation was decided in the year 2017 and the matter was remanded back to the Educational Tribunal. Then Educational Tribunal decided the case in 2023, deciding the seniority between all the three teachers. Then 2023, Lordship, now this is still pending till 2026. And I am suffering for the long pending litigation. There is not a single allegation against me, either by the petitioner and the respondent number 5. All the other teaching staff have been provincialized in the year 2013, from 1/1/2013.
No, that's all right.
Lordship.
Now, whether you are ready to argue the matter today?
Lordship, I am ready, Lordship.
My lord, I have the instruction that my lord, today, senior counsel, my lord, K.N. Chaudhary sir cannot attend the matter today. He has a very active childhood. Therefore, he has instructed me to seek some accommodation. My lord. In
No,
fact, earlier occasion also, my lord.
No, you see, Mr. Ali, several
My lord,
adjournments were granted.
My lord. I admit, my lord, but this is the
Then?
instruction, my lord.
And Lordship, I have only 4 years of service left. He is a very young person, Lordship. He has a lot of service left, Lordship. I only have 4 or 5 years of service left, Lordship.
In fact, your lordships heard this matter once, this matter. So far as the petitioner's portion is concerned, perhaps Mr. Chaudhary finished. Then I was supposed to satisfy your lordships on 2 points. Now, if the petitioner wants to refresh your lordships, then it's fine. Otherwise, it is my turn to satisfy your lordships, on 2 points.
Hmm.
Although I'm not objecting to the inconvenience of Mr. Chaudhary. He may have some inconvenience today, but I think that it is my turn to address your lordships today.
Today. Yes?
Of course, my lord, that is there, but this is the instruction that I have been given, my lord. So if your lordship may be pleased to grant one date, my lord, adjournment more, then I will definitely express that on the next date positively, sir will be there. my lord. If your lordship permits, my lord.
No. Today, Mr. Chaudhary is not supposed to argue the matter.
My lord, my lord.
Only Mr. Das will argue.
Of course, that is there, my lord. But even then, but in course of argument, if something comes, my lord, then maybe that
No,
I.
something comes, so that's all right. You are there.
My lord.
Let us do one thing. Let us adjourn the matter for today and we'll grant him last opportunity.
My lord.
Who is the petitioner here?
Petitioner is my lord, Rahman Ali Ahmed.
Heard Mr. A. Ali, learned counsel for the, who filed this application? I,
Lordship, respondent number 6.
respondent number 6. You are for the respondent number 6.
Lordship.
Heard Mr. S.K. Das, learned counsel for the applicant. Mr. Ali for the opposite party number, respondent number
Opposite party number 1, my lord.
1. Mr. Das for respondent number?
Respondent number 5 in the application.
5.
5.
Mr. Ali, learned counsel for the respondent number 1. Submits that Mr. K.N. Chaudhary, learned senior counsel for the respondent number 1 has some inconvenience today, and on such count he applies for listing the matter on some other day. Pair allowed, recess shall list the matter on
Next week.
Next week. 24.
24th. However, it is made clear that no further adjournment will be granted to Mr. Ali on this count.
My lord. I'm obliged.
Right.
Item number 9.
May I please, Lordship? Kindly see last order, 18/12/2025, my lord. In this case, my lord, though the interim order passed, my lord, there is no any issue notice to the respondent, my lord. That's why, my lord, I could not take steps, my lord. Though takes steps, my lord, arrest is kept pending, my lord. 18/12/2025, kindly see, my lord.
Heard Mr. A.M. Ahmed, learned counsel for the petitioner. Office note dated 6/2/2026 indicates that the petitioner has not taken any step for service on notice upon the sole respondent. The said office note also indicates that the trial court record has scanned copy of the trial court record has already been received. Accordingly, it is provided that the petitioner shall take step upon the respondent within 2 working days from today. Leave the matter after
Yes.
3 weeks or 4 weeks.
Yes, there is interim order, my lord.
3 weeks or 4 weeks.
4 weeks, my lord.
4 weeks. Interim order passed earlier shall continue. In the event of failing to take any step within next 2 days, 2 working days, the court will consider vacating the interim order
My lord,
passed on 18/12/2025.
actually, my lord,
On next day, we will vacate it.
my lord, actually, 18/12/2025, there is no specific direction to take steps, my lord. That's why, my lord.
No, issue notice means,
Yes.
but more direction is necessary.
My lord, as per the registry, my lord, we take steps, my lord, but it's a return back, my lord.
Next.
For hearing.
Publish.
11.
May I please, your lordship?
Hmm.
My lord, the RSA is arising out of the impugned judgment dated 29/2022, passed in title appeal number 2/2021, my lord. And the impugned judgment is reflected at page number 104 to 133. Now, my lord, at the time of admission, my lord, 5 substantial questions of law were framed. And my lord, I would just like to take your lordship to those first substantial questions of law to substantiate the same. It was framed on, my lord, 19/12/2022 in the order. My lord, may I read, my lord? 9/12/2022. SCPC SMA. For the 51 layer.
Yes, you are referring to?
My lord, my lord, this five substantial questions of law, your lordship.
Yes,
already
I have
proved,
seen it.
yes. Now, my lord, the
But
first,
Mr. Sattar, you say most of these questions are not substantial question of law.
my lord, so far,
So
one,
number one,
yes,
number one and number five.
number five.
The
So,
others are
so
question of
during,
facts.
so my lord, while giving my reply to or 1 and 5, if these three other substantial questions of law becomes relevant, then I will take your lordship to that.
So, so for the substantial question number one, question of law number one.
Yes. If I can take your lordship to the decision of the first appellate court, my lord, your lordship will not find any substantial question of this points for determination framed.
No, it may not be, but it is well
But
settled
my
in
lord,
several decisions.
the reasons for decision must be there, my lord.
Pardon?
The reasons for arriving to that decision must be there, my lord.
No, whether the first appellate court has discussed all the points.
Only the issues, my lord.
Yes.
Yes. The issues are discussed. Yes. In the similar fashion in which the trial court has discussed the same. So where lies the points for determination by the first appellate court?
No, non-formulation of point for determination is not always fatal. It is well settled.
Provided, yes, my lord, yes. It is not always fatal.
Yes.
Provided the learned appellate court has gone through the evidence on record which was very much there. Now the evidence on record shows that the lease was entered into in the year 1985 and the payment for the 1 year was to be made on the last day of February every year, my lord. Now the claim which is made by them is for 3 years. And if it is hit by Article 52, my lord, then in that case, that question ought to have been discussed by the learned first appellate court, and it is perverse in that way.
No, the first appellate court has not discussed that point.
No. My lord, for the area of revenue, for the area of rent, only 3 years is the period prescribed. Now the learned trial court has granted it for 6 years, and in the similar fashion, the first appellate court have also granted it for 6 years. That part is not at all discussed.
Does limitation act.
Limitation does not.
So the
My lord,
period is
if
for
your lordship,
period starts from?
If your lordship is perusing Article 52
Yes.
for the areas of rent, lease
Yes,
rent,
3 years.
3 years, where the areas become due or when the areas become due.
No,
So, my lord, the area according to that lease agreement always becomes due for 1 year in the month of February, at the last part of the February. So from, say, for example, my lord, if it is from 1/1, say 2026, so it will become due on 31/12/2026, and I am required to pay it within next 2 months, that is in the month of February. Now, my lord, if that area is for 3 years and the suit is filed within limitation, well and good. But it is for claim is for 6 years, and there is nothing like that of that the suit is hit by Article 52 of the Limitation.
How the trial court has dealt with that issue?
Yeah, I am taking the honorable court. Hello, the issues your lordship will be pleased to see at page number 86 and 110. 9 number of issues were framed. First, my lord, page number 86. These 9, first I would like to read before your lordship, all the issues. Whether cause of action arose for the suit, whether the suit is maintainable, whether the suit is barred by limitation, whether the defendant has violated terms of lease agreement number 6827/85, whether the defendants are defaulters in payment of rent to the plaintiff, Shri Shri Dakhin Path Satra, whether the lease deed number 6827/1985 is liable to be cancelled, whether the defendants are liable to be evicted from the co-scheduled land, and whether the plaintiff refused to accept rent from the defendant. Now, your lordship was asking about this limitation, which is issue number 3. Issue number 3. Issue number 3, your lordship will be pleased to see in detail on page number 87.
Yes.
Whether the suit is barred by limitation. From the perusal of the plaint, it is clearly discernible that the present suit is basically for ejectment of defendant number 1 from suit schedule land. Besides, the plaintiff has also sought a decree for cancellation of lease deed and for realization of area rent. Article 67 of the Limitation Act provides that in the suit by a landlord to recover possession from a tenant, the period of limitation is 12 years from the time when the tenancy is determined. Cross-examination of defendant number 2, Sabbir Ahmad, the director of defendant number 1 company, reveals that he has not disputed Exhibit 2, that is certified copy of the deed of lease bearing registration number so-and-so. Said defendant number 2 admitted in clear terms that since 2008 till 2013, the defendant company or the defendants have not made payment of early rent to the plaintiff, and that at the rate of rupees 8,554 for a period of 6 years, a sum of rupees 51,324 is payable by the defendants on account of area rent to the plaintiff Satra. The said defendant also admitted in his cross-examination that as per Exhibit 2, certified copy of deed of lease, if the terms and conditions incorporated in the deed of lease are contravened, then the lease would stand determined. On close scrutiny of Exhibit 2, the deed of lease, it transpires that one of the stipulations of the deed of lease was that if the lessee fails to pay the annual rent for each year within 28th February of each year, the lease would stand determined automatically. Accordingly, when admittedly since 2008, the defendant defaulted for payment of yearly rent as per the terms of the deed of lease, Exhibit 2, the deed of lease is liable for determination. Situated so, the present suit filed in the year 2014 for recovery of possession and for other ancillary reliefs from the time of determination of tenancy in 2008 is well within the period of limitation of 12 years. This being the position, it is concluded that the instant suit is not barred by law of limitation. This issue is accordingly answered.
So what wrong with this finding then?
Yes. My lord, there are 3 schedules in the plaint. One is for 802 bigha of land, that is for the recovery.
The main pair of the suit was for recovery of the possession.
No, my lord, all the prayers are main prayer according to me, my lord. All the prayers are the main prayer. All the prayers, whatever the prayer is made, it is on the basis of the pleading, and all the prayers are the main prayers.
Trial court has held that the recovery
trial
of
court
area rent
has-
is an ancillary relief.
No, my lord, trial court has not entered into this part of the matter when there is a specific prayer regarding the area of rent. Regarding the area of rent. And area of rent can only be paid from the date of filing of the suit next before 3 years, not after that, because it is barred by. But that part is not dealt with by the trial court. Similarly, my lord, that is also not dealt by the first appellate court. First appellate court. There is no finding at all, my lord.
No. For a particular suit, whether different period of limitation will be applicable.
My lord, for area of rent, when for the area of rent, law
Yeah,
of
that is the
limitation.
ancillary
No,
pair.
my lord, for the, okay, what is the question of your lordship? I will answer to that.
Yes, Mr. Sharma.
But it is under, I think, section 22. It is a continuing bits and blocks. Section 22 of the Prohibitions. In a case of continuing bits of the contract or in a case of continuing tort, the phrase limitation begins at every moment of the time during which the breach of trust or else case may be correct. It is a continuing bits because they have paid to deposit the land or paid the land to the plaintiff. Therefore, it is a continuation breach. There is no point of limitation.
Okay, you are referring to?
Section 22 Limitation Act.
22. Yes, Mr. Satta.
Yes, my lord.
Section 22 of the Limitation Act is there.
Yes. It is with regard to continuing breach of contract as well as my lord tort. There was a contract. Now I am coming to my lease. There was a contract that for the whole year, when the rent will become or when the rent will accrue for the whole year, it is to be paid within the February 2000 of the next year. February. This is a contract. Now, these sections are summarized in the form of my lord articles, and for which everybody has given the right what to do, what not to do under the articles. And for that, the period of limitation is that whenever I am going to claim area of rent, particularly the area of rent, and that too by way of a specific prayer, my lord, then that I can claim only within 3 years from the date of its
No,
accrual.
that's all right. Had it been only the pair in the suit,
No, there are
then
six
your
pairs.
submission could have been accepted. But here, that is the ancillary pair. Main pair is for recovery of position,
Recovery of
for
position.
which the limitation period is 12 years.
No, I am not on that, my lord.
Then,
First of all, my lord, we are to go as per the prayers made in the plant. Because this is the prayer of the plaintiff made in the plant. Now the plaintiff claims, so far the declaration is concerned, 12 years. And in a lease, my lord, in a lease, there is no period of limitation prescribed in that way because it is for 50 years. The lease is for 50 years. Suit was filed in the year 2014. My lease period was up to the year 2021. It was, my lord, in fact, from 1/1/1982 to 31/12/2021. 2021. So far the declaration for the violation of the lease is concerned, my lord, it is in respect of 508 acres of land. I am not on that. I am not on that because my lease period has not yet expired and in between the suit is filed. The suit is filed in the year 2014 for the recovery of area of rent. For the recovery of area, no, there are various prayers. First of all, I would like to take your lordship to the prayer part which is made in the plaint. Let us go to that first.
page number?
Yeah, my lord. Plaint, my lord, 9 to 16, page number 9 to 16 is the plaint. It is the translated copy of the plaint, my lord. 9 to 16 is the plaint. It is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. 9 to 16 is the translated copy of the plaint, my lord. Hmm? As my lord, page 14, prayers started. Decree and order to give khas possession of the shoot land to the plaintiff by evicting the defendants from the shoot land as the defendants violated the terms of the agreement for schedule co plot of land. Am I right here, my lord? That is co. I will come to co also, my lord. I will come to co also because that is also a substantial question of law. Now, decree and order to direct the defendants to pay the plaintiff the entire unpaid amount described in Schedule K, which is required to be paid by the defendants as per the agreement. This is a specific prayer, my lord, with regard to the rent, unpaid rent or arrear of rent, so to say. Then G, my lord, is order and decree to cancel the registered agreement number 6827/1985 executed in between the plaintiff and the defendants as the defendants violated the terms and conditions of the agreement. Thereafter, prayer Gha is also there, my lord. Order and decree to registrar office at Nagaon to cancel the agreement number so and so executed in between the plaintiff and defendants by sending precept from this court, and order and decree for the relief as the parties of the suit are entitled for. This is, my lord, the prayers, specific prayers are there in respect of all the schedules. In respect of all the schedules. So, so, my lord, when the prayers are based on the pleadings, and pleading entails that the area of rent was from 2008 to 2014, that is for 6 years. 6 years. That's why I am submitting before your lordship that whenever a recovery for area of rent is to be filed, whenever a suit for recovery of area of rent is to be filed, it must be filed within a period of 3 years. Otherwise, the rest portion will become time barred. So, for area of rent, the plaintiff has claimed for 6 years. There was no whisper about that the 3 years rent is already time barred. Only you are entitled for the next 3 years from the date of the before 3 years from the date of filing of the suit. Suit was filed on 6/3/2014. So the learned trial court has totally misconceived the law with regard to the area of rent. And similarly, my lord, there was no points for determination formulated even by the first appellate court also.
Maybe, but whether the first appellate court has discussed the same in the judgment?
My lord?
Whether the first appellate court has discussed this issue in the judgment?
Issue-wise discussion, I will take your lordship to that also. Issue-wise discussion is there. It is not the duty of the first appellate court to discuss the matter issue-wise. First of all, my lord, maybe I may be wrong, my lord, but I am submitting before your lordship that when there is a procedure prescribed for the trial court, for the first appellate court, and even for this appellate court, that is the second appellate court, whether I will, if I request your lordship to go through the evidence, whether your lordship is duty bound to go through that. No. No.
No.
Because the perversity which I am going to place before your lordship is from the judgment, that is the first appellate court judgment, as well as the trial court judgment. Trial court has never discussed it. That's why the first appellate court has also ignored the same. And there lies the perversity. That is my respectful submission before your lordship. I will come to the other point also.
No, there is one decision of the Supreme Court. I have not remembered exactly the citation. Thus.
CPC.
Go to. Yes, open asking this is- Perhaps there is a decision of three judge bench of Supreme Court.
There is, my lord.
Hmm.
I agree with your lordship
Hmm.
that the points of determination, even if not framed,
Hmm.
but substantially covered
Hmm.
in the judgment, then no need to frame points for determination.
Hmm.
But then we have to see whether that part which ought to have been under the points of determination is substantially covered.
Hmm.
Is substantially covered.
Hmm.
Your lordship is absolutely right. I have also gone through that judgment.
Hmm.
And even our High Court is also there, my lord.
Hmm.
My lord, I will take.
Hmm. Yes, Mr. Sharma, is there no discussion in the judgment of the trial court on this point? No, sorry, in the appellate court judgment.
Yes, it was discussed, but the issue number 3. Yes. Yeah, let's put it kind of it.
In which paragraph it was discussed? Appellate court judgment, appellate court,
Page 125.
paragraph number 13.
125.
No, paragraph number 13.
No, my lord, 24.
24. Okay.
It says 67 of the Limitation Act provides that the landlord can file a suit recovery of possession from a tenant within 12 years from the date of tenancy is determined. In the instant case, it is the applicant that the applicant stopped payment of the yearly rent from 2008. DW2 has categorically admitted defect in his evidence. As per clause 2 of exhibit 2, deed of agreement, a lease was automatically done in the event of non-payment of the yearly rent. Therefore, said on or before 28th day of February, each therefore by virtue of the terms of the agreement, is automatically determined in the next 29th April 2008. The suit was filed in the year 2014. As such, it is within the time. Therefore, it's not barred by law of limitation, hence is said it in the video. And madam, the one thing I want to point out, in the law appellate court, the point is very afraid was not taken as a ground. The memo appeal I had will also for the not was record.
It is part of this record. Memo of appeal is part of the record.
Yes, lower court record is not. Appellate court to do. T2 of 21.
Memo of D2 has been read, title and D2, D2. Title of D2.
Memo of appeal, so still can be. Ground number 6.
Yes.
Is ground number 6 is the point of issue number 3. Issue number 3, they have raised already Article 67 of the Limitation Act.
Memo of appeal,
Ground number 6.
para number 6,
Ground number
round number 6. Okay. For that,
for that landed court will arbitrary sentence 3 to be effected as per Article 67 of the Limitation Act is issued by the landlord to provide possession of the tenant within the period of limitation of 12 years. And when the tenancy agreement has been wrongly held. So far, the position of the land is concerned, Article 67. Only my landed friend has argued on Article 52, which is not detailed in the appeal.
okay.
Which is not detailed in the appeal. Therefore, they cannot argue on the point of Article 52 before this.
My lord, one point of submission before your lordship, whether the point of law cannot be argued even at the appellate stage, even before the Supreme Court. It is not a question of fact, it is a question of law. And moreover, my learned friend has not read that paragraph wholly. In the whole paragraph, if he reads, then that is there.
The court will be wrong, but I think that this to make it. Yes, it is. Article 52 provides it.
A fit case for remand. I will submit on other, my lord, let him reply. My senior is there.
Okay, we'll resume after 5 minutes.
Yes, my lord.
In the meantime, you go through that decision.
I will, my lord. I will. Is that whenever there is any area of rent, then recovery can be within a period of 3 years. Recovery can be for a period of 3 years, not for 6 years. Now, my lord, your lordship had asked a question to which I am also to reply, that whether the first appellate court has dealt about this, because in 4 pages, the trial court has discerned about issue number 3. But issue number 3 is finished by the first appellate court within half page. Or say, my lord, full page. I'm taking your lordship to that issue number 3. My lord, page number 125, which although my learned friend has read it,
Hmm.
125, my lord, issue number 3, paragraph number 24, my lord. My lord of the memo of appeal, my lord.
Got it.
Section 67 of the Limitation Act 1963 provides that a landlord can file a suit for recovery of possession from a tenant within 12 years from the date when the tenancy is determined. Here I would like to submit one thing, my lord. My tenancy will get determined by a flux of time only in the year 2021. But for violation, any day in between. My lord, my tenure to run the lease is up to the year 2021. 2021. But my lord, I would very humbly submit before your lordship, it can be determined provided the conditions of the lease are broken by me. Broken by me. Now, the learned first appellate court has only seen only one article, Article 67, not any other article of law. Law of limitation, I mean.
Maybe, but there is no such environment.
No, my
in
lord,
your
maybe मैंने
written statement.
maybe अपनी को अलग-अलग है तो मोर status नहीं क्या हो जाएगा. What I am submitting before your lordship is that the learned first appellate court, as your lordship has already shown me that, I mean the judgment of the Honorable Supreme Court. My lord, I am grateful for that because it speaks of the same tune which I am going to submit before your
No,
lordship.
that's all right, but if it is not there in your pleading, why the appellate court
My
will go
pleading
through
is
the
there,
same?
my lord. My pleading, I can show to my pleading. Why should I plead? It is hit by Article 52.
No, not necessary.
Limitation.
But regarding the averment,
Yes, it
that
is.
regarding this non-payment of that area.
It is there, my lord. It is there. Let me complete this part, my lord. Now, my lord, 12 years from the date when the tenancy is determined. In the instant case, it is an admitted fact that the appellant stopped payment of yearly rent from the year 2008. DW2 has categorically admitted this fact in his evidence. As per clause number 2 of Exhibit 2, deed of agreement, the lease was to be automatically determined in the event of non-payment of yearly rent, aforesaid on or before 28th day of February of each year. So when my lease is getting determined on 28th day of February each year, my lord, then within a period of 3 years for area rent, the suit ought to have been filed. That is my respectful submission. And that part is not dealt with by the first appellate court. Though he has not framed the point for determination on that whether the suit is barred by the limitation, but on the limitation, my lord, the learned first appellate court has done nothing, has not even seen the prayers also. That there are 5 or 6 prayers, all the prayers are arising out of the pleading. He has not perused, my lord. The learned trial court has not perused. That is my respectful submission. In what way the honorable court is going to take it, immaterial, but material is that in issue, while deciding issue number 3, that limitation part is not taken off, only section 67 is taken off hereof. Now, my lord.
No, my question is, while there is no such averment in your pleading, then why the trial court, no, appellate court shall go into the same?
My lord.
While it is not in your pleading, while the appellate court shall go into the same?
My lord, in my respectful submission before your lordship, I will simply submit before your lordship this is that law is not to be pleaded. Law is to be argued. Only facts are to be pleaded. And on the basis of
where you have pleaded that fact?
Yes, it is barred by limitation. I have pleaded that fact.
That is an omnibus statement. It
My
is
lord?
barred by limitation.
Yes, I have taken the plea that the suit is barred by limitation. And from the pleading,
How it is barred by limitation? Is it not your duty
No.
to establish it?
No, my lord, it is not my duty.
No,
It is the duty of the plaintiff.
The plea is taken by you, whether the burden is not lies upon you.
My lord, my burden lies upon me to simply pinpoint before the learned trial court that the suit is barred by limitation. How it is barred? It is from the pleading. And pleading, I have not filed the suit, my lord. They have filed the suit stating inter alia or alleging inter alia that from 2008 up to the year 2013, I have not been able to pay the rent.
Yes, Mr. Soma, it is whose duty to establish the point of limitation? Please taken by him. It is whose duty to establish this point of limitation?
No, who raised the point of limitation? It is his duty.
It is his duty.
Yes.
Okay.
Because burden lies on them.
Yes.
Burden never lies on the plaintiff.
No, his plea is that he has raised the issue that suit is barred by limitation.
But he has to prove how it is barred by limitation. Merely writing a line, the suit is barred by limitation. That is true. That must be proved by the defendant who raised this point. It is not the burden of the defendant. The suit is within time. It is the burden of the defendant. The suit is beyond the period of limitation. They have failed to prove that. And they have never raised in the plate, in the written statement as well as the memo of it. In the memo of it, I have already section 67. Now, my learned Why not
No.
be allowed to argue on the point of.
Yeah.
No, his plea is that the point of law can be raised at any stage.
No, it must be in the written statement.
Hmm.
It must be in the written statement. You cannot argue the case in the appellate court or the second appellate court.
Hmm.
Your basis and your base must be in the written statement. Only you can argue on the side one.
Hmm.
And in this case, it's only barred by limitation. No other is barred. Why it is barred by limitation? And moreover, there is no evidence to that effect also. And in the memo, they have specifically said, Article 67, not 52.
Hmm.
Therefore, the findings of the Lower Appellate Court is right, and it cannot be, it may not be interfered in this reality.
Hmm. Okay.
My lord, one thing I would like to submit, I am not taking the chance of my learned senior counsel.
Hmm.
My lord, I have gone through order of your lordship in one of the case.
Hmm.
I don't know whether your lordship is now remembering or not. And I was the person who came. My written statement, my lord, was not accepted within a period of 90 days. I'm just submitting before your lordship the earlier fact. My lord, whether the defendant, if do not submit the written statement within a period of 90 days, and this honorable court has also closed that event, am I not in a position to cross-examine the plaintiff within the arena of the plaint? That was your lordship's decision. I know that your lordship has gone through many civil cases, more than me, but that is the law, my lord, that even if my written statement is not allowed to be on the record, yet I have the right to cross all the witnesses, including the plaintiff, my lord, within the ambit of the plaint, not outside, because my pleading is not there.
Hmm.
Now looking to that aspect of the matter, my lord, here the pleading is, supposing, my lord, no written statement. Here the pleading is that I have defaulted from the year 2008 up to the year 2013 and have not been able to pay the rent on or before 28th day of February 2018.
Hmm.
So, my lord, that plea will be rubbish plea, my lord. No.
No, you see the finding of the appellate court that in the instant case it is an admitted fact by the appellant that the appellant stopped payment of yearly rent.
Yes.
Hmm.
I also admit,
Hmm.
being DW2, my lord, I have admitted that I have not paid the rent. Actually, if I go further, rupees 54,000 something was given by way of check, it was refused, altogether a different thing. But that will not exonerate the plaintiff to bring a case within a period of limitation for the recovery of rent, my lord. 3 years. And that part is not dealt either by the trial court or by the first appellate court. That's what my respectful submission, my lord, is. Even if there is nothing in the pleading, even there is nothing in the, say, just that's why I gave the example, taking recourse to your lordship, that order, my lord, I have not been able to file my written statement, meaning thereby I have not been able to place my cause before the trial court. Now, my lord, if there is any defect in the plaint, being the plaintiff defaulted in WS is not in a position to argue the matter on the point of limitation. When there is, the suit is specifically, I mean, that prayer is specifically barred by the law of limitation. And whereas the learned trial court as well as the first appellate court is saying that my tenancy is determined, totally wrong submission, my lord. My tenancy is not determined. My tenancy is up to the year 2021, my lord, in my respective submission. It was for 40 years. Some of the clauses I have highlighted, that's why the landlord or the lesser, my lord, has come before the court of law. Lesser has come before the court of law for the violation of some of the clauses. For that I can be held guilty of, I can be penalized for. But my lord, so far the limitation is concerned, it is his duty, not my duty, to come before the court within, because I am the defendant. He is to come before the court within the period of limitation. Limitation is for him. Limitation bars the remedy, my lord, not the right. Right he has exercised, he has come to the court after 6 years. That's why 3 years rent he is not entitled to. The learned trial court has hold wrong to that point, and the first appellate court is also wrong. With that view, my lord, I am taking your lordship to the last part of this para number 24. My lord, deed of that line number 5, my lord. Deed of agreement, the lease was to be automatically determined in the event of non-payment of yearly rent. Yes, automatically determined for non-payment of the yearly rent. Aforesaid on or before 28th day of February of each year. Now, here from the cause of action to file the suit for area rent starts. So, if I have not been able to pay on 28th of February, every year, my lord, there from the cause of action starts. And now my respectful submission before your lordship is that if this is the position of fact, then in that case, for area rent, my lord, the suit ought to have been filed within a period of 3 years. Agreement. The lease automatically got determined on the next day, that is 29th April 2008. The suit was filed in the year 2014, and as such, it is well within time. The first appellate court was having its mind, my lord, for the declaration that the lease is determined 12 years. I agree to that. But what about that part, which I have already submitted before your lordship? That the suit is hit by Article 52 for the area rent. Prayer number goes off. No whisper about that, my lord.
But we have to see the burden of proof.
Yes, as per section 100 and 101 of the earlier evidence act, my lord. Burden of proof is upon the person who asserts it. He is asserting it. Upon him the burden lies. Who asserts? The plaintiff asserts. My lord, as per section 100 and 101, the party who asserts a fact is to prove that fact.
No. Burden of plea is taken by no, sorry. This point of limitation is taken by you.
Yes.
Then burden lies upon whom?
So I have shown it. I have shown it that the claim for arrear of rent is for 6 years. The period is only 3 years, my lord.
No, maybe, but where in your pleadings you have made such averment?
In paragraph number 5.
That is an omnibus statement that is
No,
barred by limitation.
in the omnibus statement, I have narrated the whole thing.
No.
In the omnibus statement, I have narrated the whole thing because I cannot take the burden of the plaintiff's, which is lying on the plaintiff's shoulder, my lord. I cannot take that burden. I can simply cross-examine him on that. And no need to cross-examine when the very plaintiff itself speaks of that fact, my lord.
There is one decision of Supreme Court. One of the name of the party is Anil Rishi.
My lord, apni koi diyo kami ani mein tu.
No, I have not remembered the name of the other party. Anil Rishi versus someone else.
On which point, my lord?
Anil Rishi. Regarding this burden of proof.
On us.
So Anil Rishi versus.
My lord, one decision I remember, 1964 Supreme Court. I'm not having, my lord, that onus, burden of proof and onus of proof. My lord, burden of proof never shifts. It is only the onus which shifts. On that, my lord, I will satisfy your lordship. Yes. It was perhaps 1964, I think, my lord.
Yes.
Guru
Bhag Singh.
Babu, citation to the A 2006, correct.
So you come prepared on this point, burden of proof.
Yes, definitely, my lord, I will come prepared before your lordship on onus of proof and burden of proof. And apart from that, other substantial question of law, my lord. On other substantial question of law, because, my lord, if there are 5 substantial question of law, out of that, even if I succeed to 2, my matter is over. Though your lordship has said that all are not the substantial question of law, but I will take your lordship to that part also, my lord. Hey, it would little open.
You got the citation?
My lord.
Got the citation from him?
Yes. We will take it, my lord, because here there is no head note. We will take there from there, head notes are there.
So we will keep the matter as parted today.
My lord.
Heard Mr. Sutter, learned counsel for the appellant, and also heard Mr.
Yes,
S. Sharma, learned new counsel assisted by Mr. Hardad, learned counsel for the respondent. Heard in part, list the matter on sorted.
26th of March.
No, February.
26th of February, my lord. My lord, let it be in the month of March, my lord. First week of March.
Okay.
First week of March, 2, 3, 5th of March. 2, 3 banda. Oh, 3, 4 banda. Hi. Yes, 5th of March. As part heard, my lord.
Yes.
Yes.
Yes, can it be referred to the mediation? Maybe. Quantum. Yes?
Agree.
Okay. Heard Mr.
F.A. Ahmed. F.A. Ahmed.
F.A. Ahmed, learned counsel for the appellant, and Ms. Roy for the respondent. This matter is listed today under the column so and so. It is submitted at the bar that since the grievance of the appellant relates to the quantum of compensation awarded by the learned tribunal, the matter may be referred to the mediation. Accordingly, taking note of the submission of learned counsel for both the parties, this matter is then referred to the Gauhati High Court Mediation Center. Rest shall list the matter before the mediator, Gauhati High Court Mediation Center on suggested date.
2020.
The mediator shall submit a report within a period of, so they fixed cover limit. Okay. After the mediation, the mediator shall file one report before this court. The parties are directed to appear before the learned mediator on Monday. Okay.
28.
We have 6.
What? Next.
We have 19.
May it please your lordship.
Yes.
My lord, this revision petition has been directed against the order dated 13/12/2024, my lord. Here, a petition has been filed under order 7 Rule 11, my lord, praying for rejection of the plaint, my lord. And that has been rejected by order dated 13/12/2024, my lord. And against that order, my lord, this repetition, this civil revision petition has been filed, my lord. Here, my lord, case is that, my lord, the respondent as plaintiff filed a title suit with the prayer for eviction of the defendants and for permanent injunction, my lord. And there is no prayer for declaration, my lord. And their only basis for the right is an tenancy agreement with Gauhati Town Committee, my lord, on the basis of which he is claiming his right. And defendant has filed, my lord, the written statement wherein he is also stated as tenant, my lord, by dint of another, my lord, tenancy agreement. Here, my lord, plaintiff also, my lord, submitted document, the agreement, tenancy agreement, my lord. There is no mention about the shop room. So, my lord, the suit premises is not specific as per the agreement, my lord. Now, question is that, my lord, when both parties are claiming their respective right on the basis of tenancy agreement of against a particular room, my lord, first it is to be determined who has the right, tenancy right against that room, my lord. And I am, admittedly, I am in possession, my lord, since the year 2006, my lord. That is, my lord, plaint itself reflects the same. So, my lord, here petition has been filed, that is page, my lord, 33, annexure E, my lord, under order 7 Rule 11, my lord.
Oh, where is the plaint?
Plaint is, my lord, page 12, my lord, annexure A.
Page 12.
12, my lord.
And what are the pairs?
There is at page, my lord, 14. For a decree of eviction of the defendants from the suit land and handing over possession of the same to the plaintiff. A B, and then for a decree of permanent injunction over the rented premises, restraining the defendants from any sort of disturbance upon plaintiff for all cost of the suit. And for permanent injunction also, his right is required to be determined, and that can be determined by way of declaration, my lord. And there is no prayer for declaration.
So admittedly, such pair is not there in the plaint.
Plain, my lord.
Then what would be the consequence?
Then, my lord, without declaration, my lord, the eviction, prayer for eviction cannot be considered in present case, my lord. Not in all case, in present case, my lord, that cannot be considered, my lord. And for permanent injunction, my lord.
No, that pair is there. Permanent injunction.
Yes, my lord.
Permanent injunction is there.
Prayer for eviction and permanent injunction is there. But
And
that
possession is also there. For handing over possession.
recovery of possession, that is, my lord, eviction, my lord. Eviction with recovery of possession, my lord. And admittedly, in the plaint itself, my lord, it is reflected that I am in possession since the year 2006. And my written statement specifically, I have stated that, my lord, I am in possession since the year 1988 on the basis of another tenancy agreement, my lord. So Right of tenancy is in dispute, my lord.
How?
My lord, because I am claiming my possession on the basis of an agreement, my lord, since the year 1988. And the plaintiff is claiming his right on the basis of an agreement since the year 1997, my lord. Of same room,
So
my lord.
you are not disputing that agreement?
Yes, my lord, I am disputing, my lord. In my lord, my written statement, I have specifically disputed, my lord.
In which paragraph you have taken such a plea?
Paragraph 7, my lord, page 18. 7, 8.
So you have admitted that there was an agreement in the year 1988.
My lord?
There was an agreement in the year 1988.
Yes, my lord, that is with me, my lord. I am claiming my tenancy right and possession on the basis of that agreement, my lord. Rather, the defendant number 1 has been occupying the suit room under the year 1988 by executing an agreement.
So how the trial court has committed any illegality?
My lord, here, my lord, order is at page, my lord, 36, my lord.
Paragraph number?
Paragraph, my lord, 6 and 7 is relevant, my lord.
Yes.
Now, it has been well settled that the rejection of plaint would require the court to carry out a meaningful and not a formless reading of the affirmance of the plaint and the documents filed therewith. Any contentions or pleas taken by the defendant in the written statement cannot be considered under irrelevant. Here, the issue of maintainability for filing a suit for eviction and injunction without seeking a declaration in the considered opinion of this court will be an issue on merit, which may arise between the parties and would not be within the realm of what an Order 7 Rule 11 of CPC postulates. Reliance at this juncture is also placed on the observation made by the Honorable Supreme Court in Gaurav Singh versus Harvinder Singh, special leave to appeal, so and so dated 9/11/2022. In this case, the plaintiff filed a suit for permanent injunction against defendant. The defendant filed an application seeking rejection of the plaint, and the same was dismissed by the trial court, and petition challenging order before the Honorable High Court was also dismissed. While considering the SLP before it, the Honorable Apex Court had held that the aforesaid cannot be ground to reject the plaint at the threshold in exercise of powers under Order 7, Rule 11 of the CPC. The learned trial court has rightly rejected the application under Order 7, Rule 11 of the CPC, which is rightly not interfered with by the High Court. We are in complete agreement with the view taken by the High Court. The special petition stands dismissed. On the basis of, my lord, this observation, that application has been rejected. In present case, my lord, in present case, that may not be applicable, my lord, because here, my lord, claim for eviction or recovery of possession is based on the tenancy agreement, my lord, which is not sufficient because the room number is not there, line number is not there, so specific, it cannot be specifically, my lord, described. It is not described specifically. And, my lord, it is admitted position that I am in possession since the year 2006, and the suit was filed in the year 2016. So, my lord, their first right is required to be ascertained, and right would be ascertained by way of declaration, my lord. First, the right has to be declared in favor of the petitioner, my lord, plaintiff, my lord. Then only prayer for eviction and, my lord, for permanent injunction can be considered. So, my lord, my humble submission is that since there is no prayer for declaration, my lord, the consequential relief, which are eviction and permanent injunction, that cannot be granted, my lord. And if cannot be granted, my lord, this plaint is not, suit is not maintainable, my lord.
Yes.
Our issue is that I have not paid for declaration of my right to dispute privileges, so I am not entitled to get any other relief except for the doctor. By the this three cases, we don't. It is all. Order 7, Rule 11. From the plain itself, not from their irregular environments or the documents. This is just without what he has stated, rather barring the fact of without the prayer portion. The factor of disputed facts, that is the subject matter of the trial, not of under Order 7, Rule 11. Now we got whether the issue raised by the petitioner is a subject matter falls under the section, Order 7, Rule 11. That will not kindly see that one will not, that today will not.
Yes.
Very short minute. The application preferred by the petitioner to reject the plain under Order 7 to 11 of the Code of Civil Procedure has been dismissed by the trial court, which has been confirmed by the High Court. If the case of the case on behalf of the petitioner, that is not entitled. In the aforesaid cannot be a ground to reject the plain at the threshold in exercise of the power under Order 7, Rule 11 of this was clearly said. And if your lordship come to another judgment, the tier judgment. In that case, without right title interest was not paid for. And this honorable court has held that that is not a candidate. Where is the relevant paragraph?
Paragraph number?
Paragraph number 9. What is the submission? The learned counsel for the appellant established that there was
No, where is the finding of the court?
Yes, finding of the court is at page 14 below. Sorry, paragraph 14.
Yes.
Paragraph 14 and 16 below. On hearing, the learned counsel for both sides will find that admittedly there was no prayer for declaration of right title interest in the plain, but there is specific environment in the plain that plaintiff had acquired right title over the land in view of the sale deed exhibited so and so by so and so. An application under section so and so filed by the representative capacity seeking capacity, that is not required. Now kindly come to 16. We therefore hold that in view of the settled position of law, there is no illegality, infirmity in the impending judgment decree passed by the courts below declaring right title interest possession of the plaintiff. And another we got micropolis cases.
Yes. Which is the relevant paragraph?
Relevant. Paragraph 8. The learned government advocate pointed out that the plaintiff had not sought for any declaration for passing of order of the dismissal, and as such, having failed to claim the main relief, he was not
entitled to a decree for areas of cession. As I have observed earlier, the prayer clause in the plain may be defective, but body of the plain certainly contain all necessary facts upon which this court could grant the relief as may be found necessary. At any rate, I hold that the relief of the prayer can be implicit in the residuary item of the prayer clause under the description any other relief. If the plaintiff is entitled to a relief, it cannot be denied to him upon a hypothetical view, as is suggested by the learned government advocate. Similarly, no court fee was payable on the relief of declaration because payment of court fee on the consequential relief of areas of terrain was sufficient under the court fee act. So, whether in this case also it was held below. Then, even if it was not paid for below, thereby that it is not that below she cannot be granted by such relief.
Okay. Okay, we will pass the order.
My lord, I would like to refer one decision, my lord.
Hmm.
Uh, 2008 4 SCC 594. Here, my lord, paragraph 13 is relevant, my lord. Internal page 4. The general principle as to when, bottom at the bottom, my lord, internal page. General principles as to when a mere suit for permanent injunction will lie and when it is necessary to file a suit for declaration and or possession with injunction as a consequential relief are well settled. We may refer to them briefly. Here, my lord, although 3 points are there, 13.3 is relevant. May I read all my lord? Or only 13.3? Where the plaintiff is in possession, but his title to property is in dispute, or under a cloud, or where the defendant asserts title thereto, and there is also a threat of dispossession from the defendant, the plaintiff will have to sue for declaration of title and the consequential relief of injunction. Where the title of plaintiff is under a cloud or in dispute, and he is not in possession or not able to establish possession, necessarily the plaintiff will have to file a suit for declaration, possession, and injunction, my lord. Here, my lord, I am in possession. He is not in possession. And now his right, my lord, the right of tenancy is in also dispute.
No, that has to be determined during the course of trial.
My lord. But my lord, if without prayer for declaration it is not maintainable, then my lord, it can be rejected under orders 7 rule 11, my lord. That is my humble
Okay,
submission,
we'll see.
my lord.
Wait, please, Your Lordship.
Yes.
Lordship will recall on the last occasion, Your Lordship has sought for the instruction whether the payment, who will make the payment. My lord, we recollect that structural compensation matter. It was admitted in the affidavit by Kala that yes, I'm entitled. The only issue which was now, which remains is that who will pay the structural compensation?
Well, here is the case. The same name having two persons, the petitioner and the private respondent, they have same name. And the amount is only given to the private respondent. The land taken combination,
My lord will kindly see the order dated.
It here records at the time,
29A.
at the time of taking the amount, the documents have been submitted by the private respondent. But the documents, kindly allow me 2 days time, 1 or 2 days time. Let me go through the record follow. Otherwise, the query of the lordship is that we have to apprise who is going to pay the amount. That is the lordship's query.
Yes.
The National Highway Authority, they said that they have already given the amount, whatever is payable for that particular land they have given. Amount has been released to the wrong person.
My lord, will kindly see the order dated 29/8/24. It will be clear, my lord.
29/8.
2024.
Yes.
My lord, will see second paragraph on next page. The present writ petition is filed with a grievance that the compensation amount of 50,21,953 was determined as structural compensation in respect of the property belonging to the petitioner. The said amount has been paid to the private respondent who is not entitled for structural compensation. From the materials available on record, it is also seen that the Assistant Commissioner Land Acquisition Office Jorhat has already lodged an FIR before the Superintendent of Police Jorhat District, Jorhat, affirming the fact alleged by the petitioner that the land acquisition compensation has wrongly been paid to the respondent number 8, though the petitioner was entitled for such compensation. In the aforesaid backdrop, the competent authority, that is the Assistant Commissioner Land Acquisition, shall file an affidavit incorporating the following facts: whether the petitioner was entitled for compensation as claimed in the writ petition for structural damages. Number 2, whether the facts narrated in the FIR lodged by the aforesaid officer is correct. And number 3, whether the compensation amount which was meant for disbursal to the petitioner has been disbursed to the respondent number 8. Such affidavit shall be filed within 29/2024. Otherwise, the additional debt shall be remain personally present in the explain the aforesaid facts. Now, my lord, after this order was passed, the Deputy ADC has filed one affidavit. If your lordship perusses that affidavit, this is the affidavit in opposition filed by the respondent number 5.
At page number?
My lord, will kindly see para 3 at page number 95. Here, my page number is shown 95.
It will be running page
184.
184.
184.
Okay.
My lord, will kindly see para 3. That with regard to the statement made in para 3 and 4 of the petition, I say that as per the joint verification report submitted by the Jorhat West Revenue Circle, Jorhat, dated 11/6/23 in 2016, and PWD Building Division, Jorhat, dated 6/2/2016, and RCC and Assam type building of Praveen Bora, son of Bhupati, which stands on the plot of land covered by DAG number 426 and 428 of Pata number 163 and 136 at Hazari Gaon, Sarai Bohi Moza, under Jorhat West Revenue Circle, was acquired.
Yes.
From the same report of circle officer, it reveals that 1 kotha of land of DAG number 428 and 10 lesa of land at DAG number 426 of Praveen Bora, son of Bhupati, was also acquired for 4 laning of National Highway 37. Another report dated 5/11/2015 received from Jorhat Revenue Circle, Jorhat, confirms the acquisition of 5 lesas of land covered by DAG number 429 of Praveen Bora, son of Bhupati. The aforesaid plots of land were acquired for the purpose of 4 laning of National Highway 37 in the district of Jorhat. Now, kindly, your lordship will kindly see para 6. That with regard to the statement made in para 8 of the petition, I say that as soon as the anomaly surfaced, Praveen Bora, son of Rajani, was asked to appear before the then ADC Land Acquisition. The said Praveen Bora, son of Rajani, appeared before ADC Land Acquisition on 29/12/2015 and prayed for 1 month time to refund the amount deposited in his account, which actually did not belong to him. Moreover, a letter was issued to the branch manager SBI, Kotaka Pukhuri branch, dated 24/12/2015 to retain the entire amount of Praveen Bora, son of Rajani, until further orders. The circle officer of Jorhat West Revenue Circle, Jorhat, was also requested to inquire the matter and to submit the detailed report, right number so and so, dated 2/1/2016, by the then Assistant Commissioner, Jorhat. Now, kindly, your lordship will see para 10. That with regard to the statement so and so, I said that the authority took all possible measures to recover the disbursed money from Praveen Bora, son of Rajani, which is the respondent number 8, my lord. In this regard, 4 letters were sent to Jorhat Police for registering case against
Probin Bora, son of Rajani. In this connection, the Superintendent of Police Jorhat informed the Deputy Commissioner Jorhat that a case numbered as Pulibar PS case number 168/16 under section 406 was registered and charge sheeted as submitted by charge sheet number 22/17 dated 22/2/2017 under section 406/420 IPC against Probin Bora, son of Rajani for trial, and the matter is sub judice in the court of SDJM at Jorhat. Moreover, Probin Bora, son of Bhupati, himself approached to the Chief Minister's Special Vigilance Cell, Assam, and a case was registered via RE number so and so, that I further said that steps for payment has not been initiated. Now, my lord will kindly see para 11 and 12. 11, my lord, as that with regard to statement so and so, I say that as Probin Bora, son of Bhupati, refused to accept the land and zirat compensation entitled to him, therefore land and zirat compensation along with enhanced land value of Probin Bora, son of Rajani was sent and deposited at the bank as per the direction of the Court of Learned District and Sassanjat Land Acquisition, Rehabilitation and Resettlement Authority, Jorhat, while LA reference case number 13/2022, since the structure compensation was already received by Probin Bora, son of Rajani, instead of Probin Bora, son of Bhupati, hence the matter was then only to recover and to hand over the same to the right person. Steps for payment could not be initiated for direct payment of the same structure, that is double payment to Probin Bora, son of Bhupati of his own, unless an order for payment is received from the Honorable Court. Now, regarding the three questions which this Honorable Court posted on the last occasion, my lord, that with regard to the Honorable Court's order dated 29/8/2024, yes, the petitioner was entitled for compensation for structural damage. Yes, these facts narrated in the FIR lodged by the then Assistant Commissioner Jorhat are correct. Number 3, the compensation for structural amount has been disbursed to the respondent number 8 as per 3G list in respect of dark number 440, but the structure was actually situated at dark 426 and 428, which structure belongs to the petitioner. Now, my lord, after this affidavit was filed, this Honorable Court passed an order dated 23/9/2024. My lord will kindly produce that order.
Yes, now the question is who will pay the amount?
But that, for that, the records we have received and the development of records, kindly give me 1 week time. Kindly take it up tomorrow at 2 o'clock. Let me go through the record, Manoj.
No, you say in view of the affidavit file,
Logic.
is there anything to decide?
In fact, Malad, it is a fact, Malad, that the amount has been wrongly given to the respondent by 8. And it is also, as per record, Malad, the affidavit is in file that he has undertaken to return the money, but he has not yet returned. So whatever document is available in the record, let me just go through, because I could not go through. Kindly give me 1 day time. Kindly take it up at 2 tomorrow, Malad.
Okay, let it be tomorrow at
My
2
lord,
PM.
can I make a prayer? Can it be taken up on Friday, my lord? Tomorrow and day after tomorrow, I will not be there, my lord.
Friday?
Friday. Then your lordship will take it up tomorrow at 2 o'clock. My learned friend will be there. My
Okay. Tomorrow at 2 PM.
Tomorrow I will not have, but I am going to test for my lord. Monday, my lord.
No, your presence or absence will absence
This is my problem.
pardon?
This is my preoccupied. This is this two more problems.
No, now Mr. Nath will answer the question, who will pay the amount?
Yes.
But if it is by a button up to me, then I have to revise this thing because on this time I am so satisfied. Because when I hear whatever my learned friend is saying, the wrong person is not there. But my name also when I acquired that problem, I had to say them all. It's not that I am wrongly by the understand. And so far, criminal cases there, I have already been honorably acquitted in this all this.
No, we are not concerned with the criminal case
Yes,
now.
madam.
We are concerned with payment of the compensation to the petitioner.
Same thing, sir.
No, Mr. Mohanto, in this petition will not determine that question
Yes, sir, that is true.
in view of the affidavit already filed. So let it be tomorrow. Your junior may be there. Heard Mr. D. Das, learned counsel for the petition.
My lord,
And-
came.
Mr. Not learned additional, no, learned senior government advocate for the respondent number 5 and 6.
5 and
5 and 6. Mr. Mohanto for respondent number 8.
5 and
And Mr. Borough for respondent number? Respondent number 2 and 3. On the pair being made by Mr. Not learned counsel 1. Okay. Respondent number 5 and 6. The matter stands adjourned to be listed tomorrow at 2 p.m.
my lord. I'm deeply obliged.
Orders was passed, it was passed in one of the application, in one of the appeal. But though it was need to be passed in the other, because that was pointed out on the next day, my lord. And lord, that the substitution has been allowed, my lord. Because relying on the apex court judgment, saying that even if there is a mention, and since we are not opposing it, my lord, there is an order that has already been passed, my lord. By which, my lord, the substitution has been, thereafter your lordship has been pleased to fix it for early hearing on our instance, my lord.
Yes.
So basically, the orders have been passed in this, and this matter has been fixed for hearing today.
ये दोनों में order नहीं हुआ तो I guess.
Substitution has been allowed. So it's these applications have become infructuous.
नहीं ये दूसरा तो order हुआ नहीं तो.
Okay.
ये दूसरा.
So, Mr. Sutter.
Yes, my lord.
This application, interlocutor application under order 39 rule 1 and 2.
My
You are
lord.
not going to press this in.
Yes.
Okay.
Because your lordship is going to hear the appeal, final appeal, my lord.
Okay.
Oh.
Heard Mr. Sutter, learned counsel for the applicant, and Mr. Dubey for the opposite party.
Yes.
Mr. Sutter submits that though this application was filed under order 39 rule 1 and 2 read with section 151 of the Code of Civil Procedure, yet he is not going to press the same as the RSA number 91 of 17 is ready for hearing.
Yes.
Accordingly, taking note of the submission of Mr. Sutter, this IA stands closed. So you are ready to argue the matter then?
My lord.
RSA 91?
91 and my lord 90 will be heard together because one is filed by the husband, the other is by the wife.
Okay.
Deepak Datta and Bina Datta. They are wife and husband, my lord.
Now, you are ready to argue the matter?
No, that's why we have made the arrangement, my lord, that some other day, let these 3 IA be disposed. On the other day we will have.
My friend has some difficulty today. I am ready for my hearing. I understand.
So
He says,
let his part be heard then.
no, I'm not saying that. But when my friend says, we both
Okay.
have agreed,
Okay.
but I am not agreeing to it. What I'm saying, but he has some difficulty, therefore he is seeking. I am not seeking by. It should not be recorded as if an agreed order.
Okay. Heard Mr. Sutter, learned counsel for the appellant. Mr. Dubey, learned counsel for the respondent. Mr. Sutter submits that he has some difficulties to argue the matter today. And he press for listing this matter along with RSA number 90 of 2017 on service the date.
My lord, 13.
10th.
Huh? 13.
Hearing day, it should be a hearing day. 12th.
11.
11 नहीं होगा ना, hearing day होना पड़ेगा.
अच्छा, hearing क्या है?
Tuesday and Thursday.
12. Let it be, my lord, as per his 12.
I was seeking for an early date. My friend is saying that he has some difficulty, so he's ready
Okay,
for
12 February.
12/3, my lord.
12/3. Okay, 12/3. Rest shall list both this RSA on 12/3.
Oblige yours.
Turning sets.
I've taken the exception, my lord. And the lottery is, the bus is not there. From, this Balipara or area to Nagaon and Nagaon to Depot. And from there to Nagaon, it will take 1 hour. And from Nagaon to, it will take 3 hours. So, in this regard, may I say one thing, madam? Let the matter be fixed at Nagaon itself. So that the boy will come from
Where?
across 3
Nagaon.
hours.
Nagaon.
And she will come to Nagaon by taking 1 hour. It will be easier for both. the
That cannot
parties.
be done in an application under section 24 of the CPC. The court has to have jurisdiction, my lord. The Supreme Court can transfer a matter, my lord, from one court to another court, even not having jurisdiction. The submission of my lord is entirely misconceived.
Then
Section 24, my lord, does not allow the High Court, my lord, in my respectful submission, to allow a matter to be shifted to a court which does not have the jurisdiction. If he can show that it can be transferred to Nagaon, that's a different aspect for your lordship to consider. But my lord, that is not permissible, because if your lordship recalls, section 19 of the HMA, my lords, specifically confers the jurisdiction on those places, my lord, place of residence of the wife, where the matrimonial house was located, where the marriage has taken place. I do not find anything in the record that Nagaon has any jurisdiction in the matter, my lords. So the matter either goes to Tezpur or it has to go to, my lord, stays at Karbi Anglong. Now, my lords, the entire thrust of section 24 is on the inconvenience of the parties. I also have to take my witnesses from Tezpur to Karbi Anglong. Lordship will kindly consider. I have placed my case on record that I am the only lady in the house, because all even my sisters are married and staying somewhere else. Now, my lord, 6.5 hours, I placed also before your lordship, if I necessary, I can place it on record, that 6 hours, 15 minutes it takes, my lord. Morning 10 a.m. there is a bus from Tezpur, not from Rangapara. So I have to come, my lords, from Rangapara to Tezpur first, then board a bus from Tezpur, travel 6 hours, 15 minutes, by which time court time is over. And my lord, I have to stay the night there. This is, the inconvenience has to be weighed against the parties. His financial strength compared to mine is much better. He can even take a car. He's a business. Please allow me to submit. I have not disturbed you. The inconvenience of the parties have to be seen, and Supreme Court has held in 13 of decisions. The inconvenience of the wife, regardless of whatever her social status, has to be given some amount of weight more than that of the husband. And this case, my lord, where I am without, my lord, I have not filed any maintenance petition. I am without, my lord, any income. I am dependent on my father. Where do I get the resources to do all this? And the inconvenience lordship will consider. There is no direct communication. There is an admitted position now in view of the submission. So, my lord, this is a fair case for intervention under section 24.
So, Sati, one case is pending in the Tezpur court.
Yes.
So you are appearing in that matter.
Yes.
But it is that, my lord, because of the fact that, my lord, since one case has been filed by her, my lord, and why not get Tipu itself, my lord? Since because of her attitude, my lord, that this incident has been occurred. After a month, she has left the matrimonial.
You are going to settle the matter amicably.
Yes, my lord. That is why I'm that's proposal.
No. That may not be the ground for.
Otherwise, my lord, there are so many instances, my lord, so that this honorable court consider the fact that considering this, the both sides, the amicable settlement, this appropriate side has been.
Let it be.
Every time this law is not there, my lord. Some convenience is there of the parties. So Nagaon is the best way. She will come with 1 hour, taking 1 hour, and I will come by passing 3 hours or 3.5 hours.
No, you are already appearing in one case under Domestic Violence Act at Tezpur.
Yes.
That's true, my lord. Since now my financial condition is also very stable, man. I am an unemployed person. I do not have any service for them. Just I'm depending on my parents, my lord. And their parents are old age. Somehow we are living hand to mouth, my lord. And that is why one way, just I'm somehow managing to come to the test food. Why not they come to the Niku? And sometimes there may be the unification, maybe there, because of the traveling, getting by both the parties, the unification maybe there.
No, that cannot be accepted.
Unification, whether they will be united or not, that is different thing. But otherwise also, my lord.
Let it be in the passport.
Otherwise, my lord, the person has to be suffered.
No. We have to weigh the convenience and inconvenience of both the parties. Let it be in passport. We are disposing of this. And it is not agreeable to your submission that High Court has no jurisdiction to transfer a case from or within its jurisdiction.
There are so many reasons.
Look, even the cause of action does not arose in the jurisdiction of Nagaon Court. Then also this court has the power under 24.
I will attempt to convince your lordship, but in a different case, not in this case.
Pardon?
Well, this is not a proper case to argue that point, perhaps. I was just saying for the sake of it. But in a proper case, I will argue.
It may not be in the under the that act.
In one case,
Section 19 of the HMA, because that section 19 of the HMA, there are judgments, certain judgments, my lord, of various high courts. I'm not sure of this, whether of the apex court or not.
But that cannot override the power conferred under section 24 of the civil code.
There are certain judgments. I would not like to press that point. What I'm saying is that there are certain judgments which would say HMA to that extent will override the CPC. And the jurisdiction has to be there. Because if I am not mistaken, my lord, section 24B says that the court has to be competent to try the same. So the jurisdiction cannot be conferred by the court, by the High Court also.
Even in one case, madam, division bench held.
In any court subordinate to it.
Lordship.
Any court subordinate to it.
Yes.
That is the language used in the section 24.
Yes.
Anyway, we are transferring the case to passport.
Can it be Nagaon, my lord?
No. Passport.
Suffering would be more for the opposite party. Because
you settle the matter.
Person. Had it been in Nagaon, it would have been much more
No.
both the party.
No. Yes, next matter.
Lordship.
May it please your lordship. It's an appeal, RERA appeal, my lord.
It is ready for hearing.
It is ready for it. It has come up for hearing. Should I start, my lord?
Yes. Ready.
We have come against the judgment dated 26/7/2022, my lord. And the matter was admitted. There's some admission or suspension question of law also.
Judgment 26.
26/7/2022.
At page number
156, madam.
156.
Order was substantial question of law frame kora order. And the substantial questions of law were framed by order dated 7/11/2022.
That inspection was carried out as per direction of the authority.
May I just give a brief background, ma'am? The respondent agreed to purchase a villa. What we were building, we were in a plot of land, we were constructing individual villas. He agreed to purchase a villa. The a particular area was specified in the agreement to sell. It was 1877 square feet built up area, not carpet area. The built up area is not defined anywhere. The RERA Act also does not define built up area. Even our GMC Act or GMD Act does not define built up area. So with a specific understanding, I'll come to that, with a specific understanding, the area of the villa was described as 1877. During the constructions, my lord, we apprised the respondent herein that there is an increase in the area. While constructing the villa, staircase was made, a headroom was constructed, and there is an increase in area by around 473 square feet. And we had raised the demand of additional 5.7 lakhs for that additional square feet. He agreed to that. That all right, I am agreeing to so far as the area of the flat, the increase in the area is concerned, but I am not agreeing to your demand of 5.7 lakhs. I will pay 2.5 lakhs. As it stood there, my lord, we did not agree at 2.5 lakhs. So he approached the RERA, raising various grounds. I'll come to the details. The matter was decided in his favor. We came up in appeal before the appellate tribunal. During the pendency of the matter before the appellate tribunal, inspection of the premises was directed. Joint measurements were carried out. Now, what is the built up area on the basis of the measurements, my lord? There is no finding of any authority. The appellate tribunal calls for a report from the GMDA. The report comes to the appellate tribunal. The said report is not shared with us, my lord. That is taken on record on the date of the hearing, and the entire judgment is passed on the basis of that report, that the built up area is not as per the agreed figure.
No. At the time of inspection, you were there.
I'm there. My lord, some areas have been excluded in that report. Am I being able to make myself clear? Suppose my lordship is measuring this area. I am there in the measurement. Now, when the measurements go to the authority, they are calculating that this area I am not taking as built up area. The portion where this table is there is not being considered as built up area. So as a result, what happened? What area was actually measured, the built up area was brought down. The headroom was not measured. The staircase was not measured, my lord. There is a document and record where I had specifically told the respondent that while calculating the built up area, I am taking 50% of the terrace floor. That has been excluded. As a result of which, my lord, the built up area has gone down. Now, without giving us an opportunity to rebut that, because that report is submitted by the GMDA. GMDA is not even a party in the proceeding.
Maybe. It was directed as per direction of the authority.
Yes, direction. But that document has to be shared with us, my lord. Let me give me an opportunity to rebut that document. Why something has been included in built up area? Why something has been excluded? How you have interpreted built up area? From where have you taken the definition of built up area? Nothing is there. If your lordship reads the judgment, because ultimately, my lord, the appellate tribunal is the first appellate authority. It is basically a first appeal, because against that, we are coming before your lordships under 100 of the CPC on a substantial question of law. Now, without deciding anything, if I may just point out paragraph 4 of the judgment, impugned judgment at page 157, man. This is the finding.
150?
157 of the IA, my lord. Documents are. If your lordship is taking up the appeal, then it is at page 192. Then 90, only 92. If it is the memorandum of appeal, it is only 92.
Paragraph number 4.
Yes. For the purpose of deciding the appeal. For the purpose of deciding the appeal, which, lordship has got it, after hearing the parties and upon perusal of the records, lies in a narrow campus. We do not propose to go into the pros and cons of the order impugned, dated so and so. Suffice to hold that we subscribe to the findings of the RERA, my lord. Now, pausing here for a moment, my lord. Can this be a finding of a first appellate court, my lord, with utmost respect? Without any reasoning, can a first appellate court say that without going into the pros and cons, we subscribe to the view, my lord? No reasoning. Suffice to hold that we subscribe to the findings of the RERA on the question of maintainability, the legal embargo on the appellant, so and so, on alleged violation, impermissibility on the part of the appellant to claim additional money by invoking so and so, prohibits the promoter to make any additions and alterations in the sanction plans in respect of the apartment in question without the previous consent of the person who has agreed to have the said apartment. In the said order of RERA dated 28/2, it is observed that final measurement of the villa was yet to be taken in the presence of the complainants. Accordingly, a direction was made that the appellant shall get the villa number so and so measured through a competent technical person in presence of the complainant, and thereafter the complainant will make payment of the balance amount based on the actual measurement of the villa at the contractual rate of so and so per square feet, but not in any event exceeding the contracted amount of so and so. The RERA Assam also mentioned that as per the complaint, the built-up area of the villa was only so and so square feet, that is 35 square feet short of the contracted size of 1877 square feet. It is the scene that the crux of the dispute between the appellant and the respondents is regarding the actual built-up area of villa number so and so. Whereas the appellant claims that the built-up area is 2350 square feet, the respondent complainants argue that it is only 1842 square feet. The resolution of this court dispute obviously depends on ascertaining the actual measurement of the said villa. During the course of the hearing of the appeal, Mr. Simanta Das, learned counsel for the respondents, submitted that a joint physical measurement of the villa was carried out on so and so, and one of the members of the inspection team was the town planner of RERA. Having noted the same, the tribunal had passed order on 23/6/2022 calling for the records of the complaint case from RERA Assam, and also ordered that if any joint physical measurement was carried out on so and so, the same be produced along with the records. On the next date of the hearing, that is on 6/7, the following order was passed. This is an earlier order, my lord. Now, paragraph 7. The highlights of the aforesaid quoted order were that the decision of the appeal lies in a narrow compass, and that the same can be disposed of after ascertaining the actual built-up area of the villa in question. Further, that neither party disputes site measurements carried out on so and so, which is recorded in the document at page 232 of the records. It has also recorded that the list of personnel present during the inspection is available at page 233 of the records, and that to ascertain the actual built-up area in square feet, the town planner RERA is required to make necessary calculations and inform the tribunal accordingly. Pursuant thereto, the town planner RERA, under covering letter dated 13/7/22, Lordship will kindly note the judgment is dated 14, date of hearing is 14/7. At page 150, page 90, page 1 of the judgment, page 91. So the hearing of the case took place on 14/7. This document is submitted by the town planner on 13/7. Submitted a calculation sheet which shows that the total built-up area of the so-and-so flat on joint measurement as directed by RERA was 1756 square feet. On the understanding that neither party disputes the measurements of the villa carried out during the joint site visit on so-and-so, the respondent complainants therefore can only be made liable to make payment of the contracted unit rate of so-and-so per square feet to the extent of the total built-up area of the villa measuring 1756 square feet. On the limited and effective adjudication above, we find no merit in the appeal, and the same stands dismissed with the following observations and directions. So my entire appeal is dismissed on the basis of a letter dated 13/7, copy of which is not available to me, made available to me. What is there, I do not know. It is behind my back. What areas have been included in built-up area, what areas have been excluded from built-up area, I am not aware. Then the directions are given, my lord. ultimately the direction is that he will have to pay for the flat for 1756 square feet.
So what are the substantial question of law?
The first substantial question of law, whether the judgment passed by the real estate appellate tribunal is vitiated by acceptance of the inspection report on the site measurements carried on so and so, which was submitted on 22/4, but not referred to in the judgment, however accepted as evidence by the appellate tribunal, without granting an opportunity to the appellant to contest the inspection report. It is that report dated 13/7, my lord. The date is incorrectly mentioned, but it was taken on record on 13/7. LCR টা আহিছে ন? Where is that? এই document আমার দেয়া নাই।
No, whether the report was prepared in presence of both the parties?
No, not the report which is relied upon. Measurement is joint measurement. I am not disputing that. Lordship will kindly appreciate it is not that just on the basis of measurement it has been done. Some areas have been excluded. My specific case is, I'll show from the record that there is a document on record where I have shown the calculations to him, how I have arrived at 2350 square feet. I am supported by a judgment of the apex court, my lord, from a judgment which has gone from our high court, my lord, which says that what is the understanding so far as the built up area is concerned. When the built up area term is not defined in the agreement or in the law, what is the understanding of the parties as to what is the built up area? My lord, there was a lot of ambiguity. Some, if lordship knows that some builders use the term built up area. Some builders use it as super built up area. What we understand is that built up area includes not only the flat, also the common area. Super built up will include also not only the common area, even the garden, and they'll share everything. But now the RERA Act has come in, it has defined that nothing called built up area, nothing called super built up area, it is only carpet area. Definition has been brought in the RERA Act. That this is the carpet area. The carpet area will exclude even the walls. So now, in the agreement to sell, there is no definition of the term built up area. So I'll just point out the documents, lordship, if lordship kindly takes up the IA, my lord, because the documents are there.
No, first come to the substantial question of law.
Yes.
Second substantial question of law.
Whether the judgment of the learned appellate tribunal is vitiated by proceeding on the basis on calculation made on account of carpet area and not built up area. Both parties entered into an agreement, more so when none of the parties to this agreement dated 9/2 had not applied for a rectification of their mutual agreement within the meaning of section 26 of the Specific Relief Act, and whether the judgment and order passed by both the tribunal as well as the authority is vitiated on that account. Because ultimately, how this 1746 has been arrived at is on carpet area, not built up area. Certain measurements have been excluded. Ultimately, we obtained a copy of that report. It is not part of the record, but we obtained it. We saw that many areas have been excluded. My rooftop has been excluded. So that is how it has come down. The appellate tribunal was correct that ultimately the dispute is with regard to area. But at least we should have been given an opportunity that this is the report of the GMDA which has come, which is showing the area to be 1746. What have you got to say against this?
Okay. Yes, Mr. Das. So, what is your view on this point that the report was not furnished to him by the tribunal?
Which my learned friend is also agreeing to that the calculation which was done in presence of both the parties
and the member and some officials of NARA and MD. That was not disputed, but the calculation. Now the thing is that whether those areas which were left out or added, whether those can be left out or not, which I have understood. If note down the dates, the joint measurement was carried out on 10 to 2022. Calculation sheet was submitted before the appellate court on 13/7/2022. Then hearing was held on 14/7 for the next year. Judgment passed on 26/7/2022. In between that, they never raised any objection. They have waited, that what the judgments will come. If the judgments come in their favor, they would not have challenged that.
No, Mr. Das, you say.
What I'm saying so, because they are stopped from doing so well, because in between that they have got enough time to challenge that why are you why are you the appellate authority is relying on those reports, whether those reports were not.
No, Mr. Das, you say, admittedly, the report was not furnished to the appellant,
Yes, that's
right?
yes.
So if on the basis of a report, a right of a party is decided, and if such a report is not, copy of the such report is not furnished to the appellant, whether prejudice is not caused to him?
I will submit those area which my learned friend is saying that the builder area is nowhere mentioned, defined builder area. That's true. Builder area is nowhere defined. But now here in this case, we have to see on which builder area or on which understanding the parties have agreed, entered into this agreement. For that, we have to go into this agreement and the diagram. In the diagram, the approved sanction plan, there are the area mentioned which they are calculating on the basis of which the agreement has been entered into. If allows, I will fix the diagrams. In fact, that must be a record also.
এইবিলাক ৰেকৰ্ডত আছে নে?
Happy this is.
এতিয়া ৰেকৰ্ডৰ পৰা দেখোন।
Those documents were filed by me in the before the real estate.
I am not furnished with. I do not know, my lord, what is this.
That is also in the judgment.
I do not know what is there, my lord.
I'll just show, my lord, that those documents are in record.
No, let him show. So ৰেকৰ্ডৰ পৰা দেখাই দিয়ক। Difficult for me, my lord. What is being produced, I do not know, my lord.
My lord, that is the
Same principle.
approved plan.
Maybe, my lord. Maybe.
They are sanction plan.
Maybe.
I'll just show, my lord, how this build-up area has been calculated and what is the what was the understanding. Can you see this first page, my lord?
Is my learned friend arguing for the GMDA, my lord? Because the built-up area calculation was made by GMDA, not by him, my lord. So what is the understanding of the GMDA? With utmost respect, my lord, is my learned friend appearing for the GMDA? What is the understanding of the because that report is made by the GMDA and RERA, my lord. It is not by my learned friend's land.
And my lord, GMDA not need to be necessarily a party there, my lord. But the authority has power under 35 to call for the expert brief, my lord.
Of course, my lord. Who is disputing that?
Why?
I am saying, give me an opportunity. It is a case of remand, my lord. Let the matter go back to the appellate tribunal. I may be given an opportunity that a copy of the document be furnished to me. Let me say what I have to say. And then hear the matter afresh. Because if your lordship sees, I have filed an IA under order 41 rule 27. Lordship has passed an order that it will be considered at the time of hearing, my lord. There in a fresh measurement of a similar villa, my lord. Now the GMDA is giving a reading, my lord. that it is more than what is my calculation, my lord. They are saying it is 2,900 square feet built up area.
That is with refers to different villa.
Exactly, same type of villa.
Not,
So therefore, there has to be a balance maintained, my lord. In one case, the GMDA says it is 1756. I can show from the document, my lord, this entire staircase has been excluded. Whether that is correct, let me give me an opportunity. Let me file my objection to that report. Hear the matter again, rehear the matter again, and decide on merits. No one will suffer any prejudice, my lord. Let the matter be sent back. The appellate tribunal will hear it within a fixed time. Give me an opportunity to make a representation.
What is your stand on this point?
I stand is that the MD has rightly calculated the area on the basis of the approved plan, on the basis of which the parties has agreed into the agreement matter. And these approved plan are this.
No, that's all right. You argued the matter before the appellate tribunal. We remand the matter then. Give a copy to him.
That he can already certified copy take from the authority manner. That was
Yes.
on record. I have also obtained a certified copy from the authority manner.
Let him submit whatever.
My document manner.
No, let him submit whatever he like before the appellate tribunal, and thereafter let there be a fresh decision of the appellate tribunal.
But on the basis of only few minutes ago, Malala has already admitted that he is not disputing the calculation sheet, which was measured in the presence of both the parties. The calculations will be same as only the conversion. Conversion means the calculation with the build-up area. The report. Because the report is based on the calculation only. Calculation
আছে type copy
The document is there. The report.
আছে 154 I had page 154. No, মই চাইছো তাতে। The joint measurement is signed by my representative. My lord, although whether it is correct or not, now I cannot dispute, my lord, because I have not challenged this. So it will be on the basis of the measurements. But what has been excluded from the built-up area, at least let me have a say on that matter. That is what my limited prayer before this honorable court.
That's what I'm saying, madam. That this measurement, the authority will not measure again, madam.
No, not
No,
necessarily.
no.
Measure. Only thing is whether the excluded area will be included in the built-up area or not. It's right?
Oh.
If my lord observed and these things follow then.
The appellate tribunal.
And my lord, the authority will obviously authority will measure the build-up area on the basis of the approved plan, my lord, because.
No, he has already submitted that he has no objection in respect of the calculation.
Measurements, not the calculations.
Okay.
Calculation I am disputing. Measurements I am not disputing.
Measurement was taken on in the
10-2.
both the parties. That he was not disputing. On the calculation part, how this build-up area come up. And my submission is that the build-up area will be calculated by the authority on the basis of the approved sanction plan. The approved sanction plan on the basis of which the authority, both the parties have agreed into the agreement for the and the approved sanction plan is madam. Here the build-up area is defined. Although no definition is there, but the diagram from the diagram it is clearly defined, madam. How the parties has agreed to, or how the builder has agreed to calculate the build-up area.
May I make a submission, ma'am? Since your lordship is remanding the matter, lordship will say that the tribunal, the appellate tribunal will decide in accordance with law. Because if your lordship goes that it will be decided according to this and that, my lord. And
No.
Lordship will say it will decide according to law. Because the additional directions are there, my lord. There is a direction for payment of interest. So that also has to be reheard, my lord. Because without any reasoning, lordship has seen paragraph 4. I have read. There is no reasoning.
No, for remanding the matter, we have to set aside the
Yes,
finding
yes, I'm obliged. It will rehear the matter,
and to pronounce a fresh judgment.
fresh judgment.
But what my other friend is agreed upon a few minutes ago. He is agreed that he is not repeating the calculation matter.
Oh, I'm not on the calculation. There is an additional direction for directing me to pay 2% interest on the loan amount, my lord.
No,
Without any reason.
He has not disputed the measurement.
Measurement.
But he has disputed the calculation. He has disputed the calculation.
Exactly.
As some of the area have been excluded.
Yes.
While making calculation. So the tribunal will furnish a copy to him formally.
Yes. For
Yes. And afford an opportunity of being heard to him, to both the parties. And thereafter to pronounce a fresh judgment.
Yes, yes.
Only
Yes,
Yes. So, as agreed upon, we will pass this order.
Yes, ma'am.
We will set aside the
Yes,
impugn.
obliged.
Okay.
I'm obliged. Obliged.
Next.
This case, my lord, only respondent number 3 appeared, my lord. And respondent 1 and 2, my lord, has not appeared, though service is complete, my lord. Today also absent, my lord, respondent number 3, my lord. That pertains to, my lord, issue of the probate, my lord, and learned trial court dismissed the, my lord, probate case, my lord. Only on one of the ground that, my lord, no executor is appointed by the will, my lord.
So 1 and 2, they have not turned up.
Turned out, my lord. But in a trial also, my lord, there is not, my lord. Contest the case, my lord.
Who is appearing for the respondent number 3?
My lord,
Idas. Idas is not present today. Let it be after 1 week then.
My lord, that may be fixed, my lord.
Heard, Mr. Patgiri, learned counsel for the appellant. None appears for the respondent number 3. List the matter after 1 week. Should we fix a date? When?
26.
26.
Oblige.